2026.
Petition is maintainable. Issue notice returnable on 17/8/2026.
On the interim period also, Doctor.
Interim pair will not consider at this stage since granting of interim relief amounts to granting the final relief. So on next date, we will finally hear and dispose of the matter. Next date is 17/8/2026.
Highly obliged.
Yes.
Oh my God. The majority of people call for things on carrying. BA 215326.
CD was called for.
Oh, yes, it is called for.
When? There is no order.
On Friday, my lord, one unlisted matter, they moved my lord. In that day, on this matter, CD was called for, it was picked up and it went. BA 215326.
BA
215326.
21. No, that petition is not here.
That is not listed in the number.
It's fixed on 10th.
Get a call for it. 10. Okay.
One and two.
Okay. Mr. Mr. Borthakur learned additional PP has pointed out that in connection with BA number
2153.
2153 of 2026, the CD has already been called for, fixing the matter on 10th of this month. And on that day, CD may be perused to dispose of the present two application also. Accordingly, it is provided that registrar shall list these two bail application along with BA number so and so on 10th of August.
Please, Lordship. Lordship, here the petitioner's son, Lordship, died in a road accident, Lordship. And subsequently, he filed an FIR before the police station that was not registered. So he went and filed a complaint case, Lordship. That was dismissed, Lordship. That was dismissed. His complaint case was dismissed, Lordship. At this case, I think, Lordship, no notice should go. Because the accused is there. Impugn order, Lordship, at page.
So earlier you have filed any complaint case?
That complaint was filed, much Lordship. That was actually when that was filed, Lordship. He has sought for a report from the police officer, and then on receipt of the report, that was closed. And subsequently, since that was not allowed, Lordship, so he filed a second complaint, Lordship.
Whether the principle of res judicata is applicable in criminal cases?
That is to be examined by your Lordship now, Lordship. That is the ground for rejection of the
Heard, Mr.
M. Ahmed, Lordship.
Learned counsel for the petitioner and Mr. Borthakur learned additional PP for the state respondent. This application under section 438 related section 442 and 528 of the BNSS 2023. The petitioner, namely Naimul Hussain Laskar, has challenged the order dated 12/11/2025 passed by the learned additional Chief Judicial Magistrate Dima Hassam in CA case number 2 of 2025 on the ground that the complaint case is not maintainable in law, being hit by the principle of res judicata. The learned counsel for the petitioner submits that the petitioner herein has earlier filed one complaint case number. What is
That
the
is-
number of earlier case?
Earlier case was. Lordship, I have annexed that petition, Lordship. Copy of the complaint, Lordship, page 36 to 39. 1 of 25. Miss
Complaint
complaint.
case number 1 of 2025, and in the said complaint case, the learned court below has called for one report from police.
Yes, Lordship.
And after perusal of the police report, the learned trial court has closed the matter,
Yes.
and it was not decided on merit,
It was not decided on merit,
and the same was not decided on merit. And he also submits that the principle of res judicata is not applicable in complaint cases. The submission of learned counsel for the petitioner needs further consideration at this stage. Notice be issued to the respondent, returnable in 4 weeks. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition will furnish to him during the course of the day. Regis will call for the record, scan copy of the record of CR case number 2 of 2025. And also the CR case number 1 of 2025 from the Court of Learned, Additional Chief Judicial Magistrate Dimasal. Fix the matter. Fix the matter after 4 weeks.
May I please, Your Lordship?
Mm,
My lord, this is a transfer petition, my lord, regarding, my lord, NIA
mm.
case filed, my lord, before the
Where
CGM,
the case is pending?
my lord, CGM Kamrup, my lord. Here, my lord, Lordship, kindly, I may be allowed to refer, my lord, paragraph 2, page 16.
Mm.
Here, admittedly, my lord, this petitioner before your lordship took loan of rupees 1 lakh. Paragraph 2, my lord.
The case was filed by the IndusInd Bank,
Yes, my lord.
Guwahati.
Guwahati, my lord.
Guwahati.
Here, my lord,
Where the loan was sanctioned.
sanction, my lord, Silchar. Check was issued also at Silchar. And my lord, it was also sent for, my lord, payment to Silchar. And therefrom, my lord, it was dishonored, my lord. And that apart, my lord, the petitioner before your lordship is very much ailing, my lord. He took several time and tried to appear. Even otherwise, my lord, because his case has merit
Let
according to
notice go.
him, my lord.
Heard Mr. Borbuya, learned counsel for the petitioner. In this petition under section 447 of the BNSS 2023, the petitioner has applied for transferring NI case number 3409 of 2024 pending before the Court of Learned Subdivisional Judicial Magistrate S within bracket 2 Kamrup M Guwahati to the Court of Learned Chief Judicial Magistrate Kasar Silchar on the ground that the petitioner is suffering from a serious neurological disease, namely Guillain-Barré syndrome, within bracket GBS, with paralysis and other ailments, and accordingly he is unable to undertake repeated long distance travel from Silchar to Guwahati to attend the aforementioned proceeding. Mr. Borbuya, learned counsel for the petitioner submits that the petitioner took loan from the respondent bank from the branch situated at Silchar, and the check was issued at Silchar, and the cause of action of the same arising at Silchar. However, the respondent bank has filed a complaint case being CR case number being NI case number 3409 of 2024 at Kamrup in the Court of Learned Subdivisional Judicial Magistrate as 2, Kamrup M. Gauhati. And under such circumstances, he has contended to allow this petition. The submission of Mr. Barbuya needs further consideration at this stage. Notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Recess a call for the scanned copy of the record from the learned trial court. And pending further consideration, the further proceeding of NI case number 3409 of 2024 pending before the Court of Learned SDJMS 2, Kamrup M. Gauhati stands state till returnable that list after 4 weeks.
Biplab.
This case is my lord, NI case. Let-
Heard Mr. Arsipal, learned counsel for the petitioner, and also heard Mr. Portakur, learned. Portakur, you were not a party here.
Yes.
Okay.
Because it is a private case. ma'am.
Okay. This revision petition under section 438 reduced section 442 of the BNSS 2023 is directed against the judgment an order dated 38/8/2025 passed by the learned additional district and additional session judge number 3 Kamrup M. Gauhati in criminal appeal number 191 of 2019. It is to be noted here that by impugned judgment and order dated so and so, the learned appellate court has affirmed the judgment and order dated order of conviction and sentence dated 26/9/2019 passed by the learned JMFC Kamrup M. Gauhati in serial case number 5369C of 2017. Peruse the petition and the documents placed on record and also peruse the impugned judgment and order dated so and so passed by the learned appellate court and also by the learned trial court. Issue notice to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Recess will call for the record from the learned courts below. List the matter after 4 weeks. Is there any interim period?
Yes, ma'am. Because
Let the
already
report
I
come.
paid 20%, my lord.
Pardon?
20% of the order amount, the awarded amount. Because
Yes.
it was my lord, check amount was 5 lakhs. The 7 lakhs was the awarded amount. I paid to the 1,40,000 during the pendency of the court.
Being the 20% amount.
Yes, my lord. That is the order. The record will be settled.
Mr. Arsipal, learned counsel for the petitioner submits that the petitioner has already paid 20% of the check amount before the learned trial court,
Appellate court.
appellate court.
Yes,
Appellate court. That the same was withdrawn by the respondent.
complainant. By
And
the
the same
respondent
was
number
withdrawn
1.
by the respondent. And as such, he has contended to suspend the sentence so handed down by the learned trial court. Taking note of the submission of Mr. Pal, learned counsel for the petitioner, the imprisonment so handed down by the learned trial court and affirmed by the learned appellate court then suspended till disposal of this revision petition.
Record corporate from both the courts. Both the court below. my lord.
Yes.
Much obliged.
Item 6.
May I please pass over the matter for 10 minutes?
Who will appear?
My senior legal.
May it please your lordship, the rejection of my Zimma petition is the subject matter of this revision petition. Page 28 is the seizure list, my lord.
In
Page 28,
connection with which case the
Chandmari PS case number 189/25 under section 61 to 1031 of the BNS lordship. Date and time of seizure is 5/12/2025, my lord. And the report of the
What is the impugned order?
impugned order, my lord. Lordship, may kindly see the first the report, my lord. The submitted by them, my lord. Page 30 is the report, my lord. Submitted by the investigating officer.
Page 38.
Page 30, my lord.
No, I'm asking about you, the impugned order,
Impugned order, lordship, would be at page number, my lord, 39, my lord.
39.
39, my lord. May I read, lordship? By
No,
this
not
order, I shall
necessary.
decide the Jimma petition bearing number so and so filed by petitioner Srimati Fulmati Narjari, paying for custody of red color Mahindra SUV vehicle bearing number so and so. The police report as called for has been received. Heard learned counsel for the Jimma petition and also heard learned EPP. The investigating officer in his report has submitted the seized vehicle is found to be directly connected with the commission of the offence and is one of the most vital material exhibit. It is further submitted that the investigation is still in progress and therefore it is prayed that not to allow and reject the instant Jimma petition. In this case, the IO submits objection in granting the Jimma of the seized vehicle and also considering the gravity of the offence under section 101 of the BNS. In my opinion, the ground shown by the IO is genuine and the Jimma of the seized article cannot be given to the Jimma petition at this stage. There are lordships order, my lord, where my lord,
What is section 103?
one just is murder, my lord, culpable homicide. Culpable homicide, murder, my lord.
Murder.
Murder case, my lord. Lordship,
And
can we-
what is the stage of investigation?
my lord, it is of 22 cases of 2025, my lord. The FIR, my lord, we have annexed a copy of the FIR, my lord, and we have been granted interim bill. Page 42 is the order, my lord. After perusal of the case diary, 3 friends went out for outing, my lord. Because of drug overdose, 1 died, my lord. This is the whole case. The other friend is still in rehab, my lord. Page 42 is the order granted interim protection to us, my lord. After perusal of the case diary, this interim protection was granted, my lord.
Okay, Mr. Borthakur obtained one report
Yes,
regarding the status.
FIR was registered on 21/7/25. Although
Okay.
FIR was registered on 21/7/25, but the present impugned order is of 8/7/26 and the application for Jimma was also
Yes, my lord.
filed.
The mother has filed with a single mother, my lord. That's why from Kopradas she has come to file the Jimma petition, my lord.
I will get the present status of the case.
The report is already there of the investigating officer at page 29.
No,
30.
regarding investigation.
Lordship.
Heard Mr. Lal, learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the state respondent. In this petition under section 438, read 442 and 528 of the BNSS 2023, the petitioner has challenged the order dated 8/7/2026 passed by the learned judicial magistrate first class Kamrup M. Gauhati in Sanmari PS case number 189 of 2025. It is to be noted here that by the impugned order dated so and so, the learned trial court, by the learned judicial magistrate first class Kamrup M. Gauhati has rejected the petition filed by the petitioner seeking custody of a Mahindra XUV 300 vehicle bearing registration number AS13M5800, which was seized by Sanmari police in the aforementioned case. After hearing learned counsel for both the parties, it is provided that Mr. Borthakur shall produce a report before this court about the latest status of the investigation of Sanmari PS case number so and so on Monday, next Monday.
But this month, Lordship, next month, good day. Can it be on 17, my lord? 16 or 17? Any day.
17.
17. I am object.
May I please your lordship?
Mm.
Lordship, That's revision, criminal revision petition, your lordship. This petition is preferred, your lordship, challenging an impugn order, your lordship, at page number 16, your lordship, passed by JMFC, your lordship, Biswanath, your lordship, whereby the vehicle of the petition have been released, your lordship, but subject to furnishing of a bank guarantee of rupees 10 lakhs, your lordship. This case, your lordship, registered under section the Assam Cattle Preservation Act, your lordship. Now, your lordship, I have preferred this petition, your lordship. The relevant portion, your lordship, found, your lordship.
What is the value of the vehicle?
The value, lordship, that is not determined, your lordship, but otherwise 10 lakh been imposed, your lordship, as a bank guarantee, your lordship. The relevant page is page number 19, your lordship. That is C, your lordship. 19, your lordship. Already more than 95 days, your lordship, that is lying under the open sky of the police station, your lordship. Otherwise, Sundar Bhai case is there, your lordship. And lordship, with due respect, your lordship, I have preferred this petition on the ground, your lordship, that section 11, your lordship, 5, that is, lordship, that the start with the wordings, your lordship, on receipt of the report, the judicial magistrate first class, your lordship, may, your lordship. It is the discretionary part, your lordship, on the part of the magistrate, your lordship. Though that is there, your lordship, that bank guarantee, furnishing of the bank guarantee is there, your lordship, but
You have the insurance certificate of the vehicle?
insurance certificate, your lordship. I must have, your lordship, but I don't annex with this petition, your lordship.
You
Okay.
what is the certificate? We will see.
Lordship.
Heard. Ms. Bora, learned counsel for the petitioner. Mr. Porthakur, learned additional PP for the state respondent. In this petition under section 438 and 444 of the BNSS 2023, the petitioner has challenged the legality, propriety, and correctness of the order dated 16/5/2026, passed by the learned judicial magistrate first class in connection with Zingria PS case number 31 of 2026 under section 302 of the BNSS read with section 11(1)(a) of the Prevention of Cruelty to Animal Act 1960 and with section 13(1) of the Assam Cattle Preservation Act. It is to be noted here that by the impugn order dated so-and-so, the learned magistrate has rejected the petition, has allowed the petition seeking custody of the vehicle bearing registration number AS01SC 5549 in favor of the petitioner, subject to furnishing bank guarantee of rupees 10,000, equivalent to the market value of the aforementioned vehicle. Having heard the submission of learned counsel for both the parties, it is provided that Ms. Bora, learned counsel for the petitioner, shall produce the insurance certificate of the latest insurance certificate of the vehicle on
13th. Lordship.
13th of August. Sorted. By filing an additional affidavit. Mr. Porthakur, whether record will be required? Not required. Not required. Okay.
Much
List accordingly on 13th.
11th.
11th. Oh.
Much appreciated.
Let's hit your road. But this is a criminal petition. This petition has been filed for quashing the order dated 11/2025, passed by the learned additional CGM Huzai in connection with NI case number 8 of 2022, and for quashing the order dated 25/11/2025, passed by the revisional court learned session judge Huzai in criminal revision case number 7 of 2025. The order 11/3/2025
which order has been passed by the learned trial court. That order has been passed on an application filed under section 311 CRPC passed by, which is filed by the accused, I mean the present petitioner Jitu Bhaiya. And that petitioner is rejected by the learned trial court. And that is why he preferred a revision application before the session judge, honorable learned session judge Huzai.
What is this? The trial is pending.
Yes, it is the trial is pending before the learned additional CGM Huzai.
At what is this?
Evidence test.
Evidence.
Evidence test.
Evidence
With-
for the prosecution or for the defense?
I am for the defense. Yes, petition was filed by the defense. 311 petition, CRPC petition was filed by the defense. Earlier,
No, the case is pending for examination of the prosecution witness or for examination of defense witness?
examination of the prosecution witness.
Prosecution witness. How many witnesses have been examined?
PW1 was examined. Only the
Examined.
PW1 was examined, cross-examined. PW1 was given the evidence in chief on affidavit.
Mm,
Thereafter, cross-examination is done
mm,
by the earlier engaged counsel.
mm.
After going through the record by the new engaged counsel, it has been seen that only 2 questions is put forwarded. No question has been rendered to the complainant regarding facts of the case and also on exhibit.
No, but you tell me whether change of counsel is the ground for recalling the witness already
No, Lordship.
examined?
No, Lordship, but fact is that if Lordship kindly see the page number 33, 34.
You first answer my query.
Lordship, only the 2 questions has been put forwarded. If Lordship give permission to read over this, I am
No, not necessary.
page number 33, 34.
When the recalling of witness is permissible under the law,
Lordship, under section
whether
311.
change of counsel is the ground for recalling the
Lordship,
witness,
But not only the changing advocate, changing
then
advocate is the petition has not been filed mere on that ground, Lordship. But subsequently on the basis of cross-examination, which has been conducted by the earlier engaged counsel. So I think proper adjudication would not be done. That is why.
now you cannot fill up the lacuna.
Lordship, that is not, Lordship, only 2 questions has been put forward.
Maybe.
And rest of the
Who
parts is
prevented you
subsequent.
from asking as many as 1,000 questions?
Lordship,
Who
There-
prevented you?
Lordship, only 2 questions has been not facts on facts of the case. That is not a single question. And on the other hand, not in exhibited documents, Lordship.
You show the ground. Otherwise, we will dismiss the petition with cost. Whether change of counsel is the ground for recalling a witness.
Otherwise, also, it's second revision petition.
Second revision petition is not maintainable.
No, that is not a criminal, that is criminal petition under section 528.
Page 35.
Okay.
Learned session that criminal revision case number 7 of 25.
Hmm. Better you come prepared on what ground a witness can be recalled. Heard, Mr. Your name, please.
Mr. A. Zaman.
Learned counsel for the petitioner and Mr. Borthakur, learned additional PP for the state respondent number 1. The order dated 11/3/2025 passed by the learned trial court. No, passed by the learned additional CJM. Huzai in NI case number 08 of 2022. And also the order dated 25/11/2025 passed by the learned revisional court. Passed by the learned session judge Huzai in criminal revision petition number 07 of 2025. Or the subject matter of challenge in this petition under section 528 of the BNSS 2023. It is to be noted here that by the impugn order dated 11/3/2025, the learned additional Chief Judicial Magistrate has rejected the petition filed by the petitioner for recalling the PW1 who was examined by the complainant, the respondent hearing. And by the order dated 25/11/2025, the learned session judge has affirmed the order passed by the learned additional chief judicial magistrate dated 11/3/2025. The learned counsel for the petitioner submits that the erstwhile counsel of the petitioner has put only two questions to the PW1. And subsequently, a new counsel was engaged who has suggested for recalling of the PW1 for further cross-examination. And to that effect, one application was filed for recalling PW1, which came to be dismissed by order dated 11/3/2025, and the same was affirmed by the learned session judge in criminal revision number 07 of 2025. The learned, but during the course of hearing, a query was put to the learned counsel for the petitioner as to on what grounds a recalling of a witness under section 311 of the erstwhile CRPC is permissible. The learned counsel for the petitioner could not answer and pressed for time. Pair allowed, list the matter on next Monday. As part heard.
And in this matter on instructions, I may be permitted to withdraw. On instructions, I may be permitted to withdraw.
Heard, Mr.
K. Talukdar.
Learned counsel for the petitioner. Mr. Talukdar submits that he has the instruction to withdraw this petition. Accordingly, this criminal petition is thus disposed of on withdrawal.
I'm good.
Liberty? Not required.
Liberty.
With liberty.
With liberty.
However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
I'm good.
Item 11.
May I please, Lordship? Lordship, this is an application under section 528 of BNS, my lord. Lordship, page number 18, the affair, my lord. My lord, may I read it, my lord?
For causing the FIR and search it.
Affair search it, my lord.
What is the offense? 337 and 308.
My lord, as per the affair, my lord, I forced the Aadhaar card of the informant, my lord.
Pardon?
I forced the Aadhaar card of the informant, my lord, and demanding money.
Okay.
My lord, admittedly, I borrowed some amount from the informant, my lord, and on this account, my lord, she has lost multiple cases against me, my lord. GR case number 1491/23, my lord, and Tezpur case number, PS case number 63/35/23, NI case number 480/24, multiple cases, my lord, and I admittedly borrowed some amount, my lord. And in that cases, my lord, I am facing the trial, my lord. And out of frustration and only to harass me, she lost this affair, my lord. That's why at this stage I'm
Heard,
only
Mr.
paying
Your name, please?
MH Soikia, my lord.
Learned counsel for the petitioner. And Mr. Borthakur, learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has tried for setting aside and causing Gitanagar PS aside the FIR of Gitanagar PS case number 222 of 2024, the search sheet number 03 of 2025, dated 29/1/2025. corresponding to PRC case number 684 of 2025,
my lord.
registered under section 337 stroke 308 BNS 2023, pending before the Court of Learned JMFC number 3 Kamrup M Gauhati, and also the order of taking cognizance dated 7/3/2025 and all subsequent orders.
My lord.
Where is the petition and the documents placed on record? Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Portakur entered appearance and received notice. Registrar shall call for the record from the learned. Call for the scanned copy of the record from the learned trial court. List the matter after 4 weeks. Is there any interim pair?
My lord, feel that, my lord, in the Learned Trial Court proceeding may be stayed, my lord.
Well, otherwise considering that he has more the photograph of the informant, and by using that more photograph, he also used her Aadhaar card, and later on, she find that in her photograph by one, where the informant, he showed one name of one Anjumani Bhatt. So offenses are to be allegations of PDS.
Interim order of the petitioner will be considered on receipt of the record from the learned trial court on next
My
date.
My lord.
Well, by this petition, my lord, my right to cross-examination has been closed. My lord, this is a petition under 582 CRPC. My lord, the impugn order is at page 27 annexure 3.
Page number, where is the impugn order?
27, my lord.
27.
My lord, in sixth paragraph, my lord,
Hmm?
in paragraph 6, my lord, it has been stated by the honorable court, my lord, that the cross is fixed from November 24, my lord. That is not correct, my lord. The cross is fixed. First date, my lord, was 13/2/2025. And thereafter, my lord, on 3 occasions, my lord will see paragraph 7 of my petition. We have narrated the entire dates in a chronological order. Paragraph 7, my lord, page 5 of the petition. The first date which was fixed for cross-examination, my lord, was on 13/2/2025. Thereafter, my lord,
So,
No.
no, as per your own statement, you have availed as many as 8 dates.
no, my
8
lord,
adjourned.
out of those 8 dates, my lord, 3 dates the trial court was on leave. That I have explained. My lord will see page paragraph 15.
Okay, how many adjournments you are entitled to?
My lord, under this is a proceeding under NI Act, my lord. Under the
All right.
NI Act, summary procedure is followed,
All right.
and there is no provision for closing the evidence has to be taken. The trial, I have gone through the provisions of
Hmm.
CRPC.
Even after 10 years or 20 years also?
No, my lord, that way, my lord, will see the NI Act prescribes 6 months
Hmm.
for completing the trial.
Hmm.
Nowhere
Then,
it is followed, my lord.
Then,
That way, my lord, within 6 months, the trial has to be completed, statutory period under the NI Act. Lord,
Mm.
prejudice will be caused, my lord. I'm simply praying, my lord. Some cost may be imposed, my lord.
no. Already cost was imposed upon you.
My lord.
Whether you have paid that amount.
No, that day we were paying, my lord, but the court has closed the matter and fixed it for argument. We were ready to pay. And my lord, at page 7, paragraph 15, I have mentioned the dates, my lord. It is on 3 days.
So the mandate of the NI Act is that within a period of 6 months, trial has to be completed. And
Lord,
you have
here, my
taken
lord, even
adjournment more
for
than 1 year.
submitting the defense evidence, my lord, 8
Mhm.
months were granted to the accused. 8 months. My lord, that will cause, my lord, serious
Mhm.
prejudice, my lord. That is my humble submission, my lord. NI Act
Serious
proceedings.
prejudice, all right. You have to demonstrate how this impugn order is illegal.
My lord. First explanation is, my
Mhm.
lord, that out of the first date was not 13 to 25, paragraph 15 of my petition.
We'll see the record.
Facts, my lord.
Heard Mr. Gupta, learned
My lord,
counsel for the
7, 8, my lord, it is fixed for final argument till that date, my lord.
learned counsel for the petitioner and Mr.
Medical
Thakur, learned additional PP for the state respondent. In this petition under section 582 of the BNSS 2023, the petitioner has challenged the order dated 1/7/2026 passed by the learned judicial magistrate first class Kamrup M at Guwahati in complaint case CR number 5426 of 2017. It is to be noted here that by the impugn order dated so and so, the learned trial court has rejected the petition number 2207 filed by the petitioner for seeking adjournment of the case for cross-examination of DW1 and thereby dispense with the cross-examination of DW1 and fix the matter on 7/8/2026 for argument. Or you produce the certified copy of the orders, we will see.
All the orders, my lord.
Mm.
But I have mentioned in my petition,
No,
all the, my lord,
mentioning will not
from paragraph
suffice.
7 onwards, each
After
date I have.
hearing learned counsel for both the parties, the learned counsel for the petitioner is directed to produce the certified copies of the orders. Certified copy of all the orders it's before this court on no, sort that. We are not granting any stay. On 6 tomorrow.
My lord, 7th is the date fixed for final argument. My lord,
Yes,
If
not
otherwise,
final order, it is for argument.
final argument, my lord. 7th, 8th, my lord, is fixed for final argument, my lord. If the final argument is done, my lord, we will be seriously prejudiced, my lord.
You to produce it tomorrow?
Tomorrow, my lord.
Yes,
My lord, we will fix it tomorrow,
tomorrow.
my lord.
May I please, Your Lordship? My lord, criminal petition, my lord, under section 528 BNSS, my lord, whereby I'm praying for quashing, my lord, entire proceeding of my lord CR case, my lord, which is pending before the my lord judicial magistrate first class at Harvey. My lord, this petition we have filed under basically two grounds. One is, my lord, entire case is, my lord, in civil nature. Another is, my lord, there is a non-compliance of, my lord, mandatory provisions of section 173 BNSS. Earlier it was 154, my lord, CRPC. Let us kindly see the facts of the case as at page 16, my lord. Para 3, my lord, page 16. May I read, my lord?
Yes.
On 27/12/24, the complainant and accused had executed a vehicle rent agreement, wherein it was mutually agreed that the complainant, that is second party in the vehicle agreement, would pay a sum of rupees 5 lakhs to the accused, and accordingly on the day of execution of the vehicle agreement, the complainant has paid an amount of rupees 2,50,000. Remaining balance amount would be paid within half month, 1.5 month, commencing from the day of execution of the said agreement, with an intention to purchase the vehicle bearing registration number so and so and so. Now, kindly see, my lord, para 4, that it is also agreed in between both parties that the complainant would pay the monthly installment rupees 90,000 for 38 months to the concerned financial company. And accordingly, the complainant has also paid for 4 installments after the execution of the vehicle agreement. 2 installments has been paid to the accused in his account amounting rupees 1,80,000, and another 2 directly paid to the, my lord, concerned financier. That as per said agreement, the complainant has performed his part of contract, my lord, by paying the advance consideration to the accused and paying the monthly installment, and he has also ready to pay remaining installment to the concerned financier, agreed in between both parties, my lord. Dispute, my lord, relating to the, my lord, one vehicle rent agreement, and after that, my lord.
Okay, let notice go at this essence.
My lord, yes, notice is required, my lord. Before that, I'd like to submit, my lord, before filing this case, the complainant issued a demand notice to me. That is also annexed here. And in that demand notice, he clearly stated that he demanded either return by his advance amount or vehicle return.
Okay, we will
And there is
consider,
some, my lord, contextual dispute between the two parties.
we will consider that at the time of final hearing. And what provision is violated?
Yes, my lord, kindly see on that part. 173. My lord, information and cognizable cases, my lord. And before filing before the, my lord, complaint case, the victim party, my lord, must have approached before the officer in charge of police. If not taken any action by the officer in charge, then he can approach before
Where is the bar?
173(4), my lord.
Whether
173
that
subsection 4.
section put any embargo in filing a
Yes, my
complaint
lord.
case?
Priyanka Srivastava case, Honorable Supreme Court decided this issue, my lord. There's a stated that it's a mandatory for the complainant before filing complaint case, he have to approach before the officer in charge.
Where
If-
is that decision?
Yes, my lord, I'm placing before the close.
Is it Bortakor, is it the proposition of law?
Yes, for filing a complaint, they can use
Before the.
No, is there any provision in the BNSS or CRPC?
Yes.
And thereafter, 175. 170.
BNSS or CRPC?
Subsection 4.
Any person agrees police station to record the information referred to subsection 1. Then the substance of this information in writing and by the police concerned who is satisfactory.
Section 173?
3 is subsection 4.
Section 4.
So is it a bar in approaching the court directly without filing any FIR before the police station?
In case of publiable offenses or non-publiable cases.
This kindly see the Ranjit Singh judgment I have placed, my lord, para 7 and 8.
No, after going through this subsection 4 to section 173, can it be said that it put an embargo upon the complainant to file a complaint case without approaching first the concerned police station.
Yes,
You will have to, the illegal document kindly come to 175 subsection 3.
Mm.
Then you will have to submit any mistake involved in section 175 considering the application uploaded by an applicant. So he has to submit an application under subsection 4, section 175. Then after making such inquiry, we can test the now, my lord, here in this case, one other aspect is also there, whether this is a, my lord, offense.
318 and 316.
Yes, Priyanka Srivastava case, so which paragraph you were relying upon?
My lord, under section 318, cheating, and 316 criminal breach of trust. These two sections.
Paragraph number?
My lord. At my lord, page 15, my lord, offense under section is stated. Page 16, bottom part, my lord. Sorry,
No,
page
tell me
15.
the paragraph number of the Priyanka Srivastava case.
On which ground I,
Priyanka Srivastava.
my lord,
In which paragraph it is stated?
about sections. Copy of Priyanka Srivastava, my lord. I am relying on that. Yes. My lord, para 13. Para 13 of my petition.
Here, nothing, complaint has been removing offense under section 316 and 318 is also there. 316 is that is found to be on the criminal breach of trust.
Hmm.
Para 13, my lord, I am relying on
Hmm.
Priyanka Srivastava.
Yes.
Stated that the said complaint petition is also liable to be rejected for non-compliance of the mandatory requirement under section 173 subsection 4 of Bharatiya Nagarik Suraksha Sanhita, corresponding with, my lord, 154(3) of the
Which one?
CRPC.
Priyanka Srivastava.
My lord,
Which case you are reading?
I'm my lord, I'm reading my lord, petition. Now, my lord, Priyanka Srivastava judgment paragraph 31, my lord, kindly says. Para 31, Priyanka Srivastava judgment.
Hmm.
We have already indicated that there has to be prior applications under sections 154(1) and 154(3) while filing a petition under section 156(3). Both the aspects should be clearly spelled out in the application and necessary documents to that effect shall be filed. The warrant for giving a necessary giving a direction that an application under section 156(3) be supported by an affidavit is that the person making the application should be conscious and also endeavor to see that no false affidavit is made. It is because one an affidavit is found to be false, he will be liable for prosecution in accordance with law. This will deter him to casually invoke the authority of the magistrate under section 156(3). That apart, we have already stated that the veracity of the same can also be verified by the learned magistrate regard.
No, whether your case, your case comes under the section 156(3).
Yes, my lord, he has filed the complaint petition under 156(3), my lord.
And the court has taken cognizance.
Yes, my lord, court issued pre-cognizance notice to me. And
Hmm.
after APR,
Hmm.
receiving that notice, I have APR before the my lord, trial court, and I have filed a petition under section 168 BNSS
Hmm.
to drop out the entire proceeding. But
Hmm.
said petition not considered, my lord. And not considered also, not rejected also till date after my lord, so many days given.
Okay. Let notice go at this instance. Heard Mr.
AK Azam.
Learned Counsel for the petitioner, Mr. Parthakur, learned additional BP for the state respondent in this petition under section 528 of the BNSS 2023. The petitioner has challenged the order dated 3/1/2026 passed by the Judicial Magistrate First Class Hajo Kamrup in connection with share case number 34 of 2025. It is to be noted here that by the impugn order dated so and so, the learned trial court has issued pre-cognizance notice upon the petitioner and also directed the respondent number 2 to take step to upon the petitioner and fix the matter on 21st of February 2026 for appearance. Where is the petition and the documents placed on record? Let notice be issued to the respondent returnable in 4 weeks. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Ms. Aborthakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. SSL call for the scanned copy of the record of CR case number 34 of 2025 from the learned trial court. Interim pair of the petitioner will be considered on receipt of record from the learned trial court. List the matter after 4 weeks.
Any date?
Correct.
14 September. I'm obliged.
May it please your lordship. Lordship, I have filed this criminal petition for quashing of the FIR, lordship. The allegation is that, lordship, I am an advocate by profession, lordship. And the allegation is that I have kidnapped a girl and I'm trying to forcefully convert the religion, lordship. The FIR has been filed by the brother of the victim, lordship. The victim is before your lordship as respondent number 3, lordship. In this case, lordship, my case is that I have been in relation with respondent number 3 from last 8 years, and I have married the respondent number 3 in the year 2025, and we both are practicing before the court in Dhuburi, lordship. So, lordship, and I have given the victim has given the statement under 164 statements, lordship, wherein she has already stated that she is married to me, lordship. And also that she has given an affidavit to that effect that this case has been filed by the brother wrongly, and there is no such kidnapping or any such sort of thing, lordship. And lordship, may kindly see page number 26, where that is my marriage certificate, lordship. The allegation of forceful conversion is also absolutely incorrect, lordship. Lordship, may kindly see page number 26. I have invoked that special marriage act, lordship, and Mr. Abdullah Ashraful
Let the record
Munin
come, we
Ahmed,
will see.
lordship,
Let the record come, we will see.
lordship. Lordship, the respondent number 3 is before his honorable court. She is my wife.
Heard Mr. Deka, learned counsel for the petitioner. Mr. Borthakur, learned additional PP for the state respondent. And Miss
TJ Sariwala. TJ Sariwala.
learned counsel for the respondent number 3. In this petition under section 528 of the BNSS 2023, the petitioner has tried for quashing the Gulugans PS case number 138 of 2026 under section 61 within bracket 2 stroke 87 stroke 127 within bracket 2 of the BNSS 2023 and the corresponding GR case number 685 of 2026 pending before the Court of Learned Judicial Magistrate First Class, Dhubri.
The case is under investigation stage, lordship. Golakganj PS case, lordship.
Peruse the petition and the documents placed on record. Let notice be issued to the who lodged the FIR.
The brother, lordship. That notice may go to him, lordship. Brother of respondent number 3, lordship.
Let notice be issued to the respondent returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 and 3 since Mr. Borthakur and Ms. Sahayola entered appearance and received notice for respondent number 1 and 3. However, extra requisite copy of the petition be furnished to them during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. Registrar shall call for the record from the scan copy of Mr. Bortakur learned additional PP shall produce the case diary before this court on next returnable date. Learned counsel for the petitioner submits that the petitioner is a practicing advocate of
Dhuburi Bar. Dhuburi
which
Bar.
place? Dhuburi.
Dhuburi.
Of Dhuburi, and the respondent number 3 is also a practicing advocate, and they got married under the special act. However, the brother of the respondent number 3 have lost the FIR upon which Guluganj PS case number 137 of 2026 has been registered. And that the respondent number 3 voluntarily got married with the petitioner, and the relevant marriage certificate is enclosed with this petition at page number. Marriage certificate is page number
26, Lordship.
26, annexure 5 of the petition. And under such circumstances, he has contended that further investigation of Guluganj PS case number 137 of 2026 may be stayed till returnable date. Accordingly, taking note of the submission of learned counsel for the petitioner and the respondent number 3, and also the learned additional PP, further proceeding of Guluganj PS case number 137 of 2026 under section so and so stands state till a returnable date, list of proceedings.
Highly obliged.
Well, the petitioner is made a gift against the order, my lord, for framing charges, my lord. Under section, my lord, 85, 89, and 92, my lord. And initially, FIR was lost, my lord, and that was registered under section 85. And kind of look, my FIR is dated 11, my lord, page. 11 the FIR, my lord. Married, no?
Not necessary. Where is the impugn order?
Impugn order, my lord, is page 49, my lord. And the relevant person is, my lord, page 52 last person, my lord. 52, my lord.
Page number
52
52.
is the relevant person, my lord. Page- We start from 49, my lord. Court has not discussed anything, my lord. Court has not discussed anything, my lord, about the ingredients of, my lord, section 89 and 92, my lord. When my lord, medical reports say negative, my lord. Negates the, my lord, entire case.
Maybe
But kindly look at page 31, my lord. Kindly look, my
it
lord.
is section 498A.
No, my lord. 85, 89, 92.
Okay.
And while granting bail, my lord, this honorable court, my lord, clearly stated that, my lord, there is no ingredients of section 89 and 92, my lord. This is, my lord, page, kindly have a look, my lord.
Whether
Page
that
21.
observation was made after perusing the case diary.
My lord.
Whether that observation was made after perusing the case diary.
Initial stage, my lord, that was made, my lord, and subsequently, my lord, when my lord, final order was passed, my lord, that was also, my lord, reflected, my lord.
Observation was made only for the purpose of granting bail or
Right.
rejecting
My
bail.
lord, my lord, to fulfill the ingredients of 89 and 92, my lord,
Hmm.
my lord, medical report must be supported, my lord. My lord, kindly look, page 31, my lord. 33, my lord, kindly have a look, my lord. 33, my lord. My lord, paragraph number 3, my lord. My lord, third sub-paragraph, my lord. Page 33, kindly have a look. Third paragraph, my lord.
Yes.
My lord, during the continued course of investigation, the victim was sent for medical examination
to Hilamara BPSC. The medical officer examined the victim and issued an inquiry report. It was medically confirmed that the victim was pregnant at the time of examination. Importantly, as per the medical opinion, although the victim has suffered a miscarriage, the abortion was unlikely to have resulted from any trauma, physical assault, external force. The medical opinion satisfactorily altered the nature of the allegation concerning the attempt of miscarriage. These are medical report. Even then, it was submitted under section 8992. And I have submitted my lord.
Let notice go, let record come, we'll say.
Because 89, it may be a case of 85. It's a cruelty, maybe, my lord. But 89 and 92, there is no inquiry.
That is a matter of trial. The court will look into after the.
Prima facie, it is a case of no ingredients. But prima facie, this is a miscarriage that was altered by the medical report. The prima facie, there is no ingredients. The court has to look after, before charging the
How the miscarriage had taken place, whether in the medical report the doctor has described.
That is in the search sheet, madam.
No, search sheet is not conclusive proof. Whether medical report you have enclosed here.
On the basis of the medical report, this search sheet is part.
I am asking you whether medical report is part of this petition.
No, I cannot submit the medical reports, madam.
Then you collect it, otherwise we will not call for the record also. Heard, Mr. Honikor, learned counsel for the petitioner, and Mr. Bortakur, learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated
25
November
my petition is
2025.
rejected and 14.5 minute charge suspended.
When charge was framed?
14.5 minutes.
No, here you are praying for quashing the proceeding or the impugn order?
Impugn order, madam. For framing charges, madam. Page 12.
Challenge the correctness or otherwise of the order dated 25/3/2026 as well as 14/6/2026 passed by the learned session Judge Lakhimpur in session case number 08 within bracket N/26 under section 85, 89, 92 of BNSS 2020 BNS 2023 arising out of Gilambara PS case number 41 of 2026. Mr. Khonikor, learned counsel for the petitioner, submits that though no ingredients of the offense under section 89 and 92 are made out against the petitioner, the learned trial court has framed charge under the aforementioned section. And that the medical report as mentioned in the charge sheet has also not supported the allegation made in the FIR. And as such, framing of charge against the petitioner under section 89 and 92, according to Mr. Khonikor, is illegal. However, perusal of the record reveals that Mr. Khonikor, learned counsel for the petitioner, has not enclosed the medical report with the present petition. Accordingly, it is provided that Mr. Khonikor shall bring on record the medical report of the victim by filing an additional affidavit on or before
Diplomas.
Number 47.
May I please, Your Worship? I have taken steps, my lord. Office note says, my lord, service is awaited now.
হবে এইবোৰ দেখিছেনে কেনেকে নোট লিখিছে awaited এনেকে লিখে নেকি বেলেগ এখন কাগজ নাই নেকি হাইকোৰ্ট office note dated 1/8/2026 indicates that service report and TCR are awaited. List the matter after 1 week, awaiting service report upon the respondent. And recessal also issue reminder to the learned trial court for transmitting the record. This after 1 week.
Interim order may continue.
Interim
order passed.
Interim order passed earlier shall continue.
I am clear.
None appears for the petitioner on call. List the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
49.
How about Mr. Borthakur, learned additional PP for the respondent number 1 present.
This case is from continuation of delay of 197 days. In that regard, my
IA is for condonation of delay.
delay. So far that part is concerned.
Whether notice was served.
One notice was issued and as per track concerning report, my lord, that was delivered on 29th of June. By speed post, my lord. And last occasion, my lord, I was to submit the additional affidavit, which I have, my lord, submitted, and that is perhaps tagged with the report, my lord.
Heard Mr. Sharma, learned counsel for the applicant. Additional affidavit filed by the applicant indicates that notice was delivered to the respondent opposite party on 29th of June 2026. But no one remained. But the opposite party stroke respondent remain unrepresented today. Who is appearing for the state here? State is a party.
My lord.
Mr. B. Sharma for the respondent number 1. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 197 days in preferring criminal revision against the judgment and order dated 22nd of August 2025 passed by the learned additional session judge Udalguri in criminal appeal number 21 of 2024. Whereby the learned appellate court has affirmed the finding of the learned trial court and also affirmed the sentence passed by the learned trial court. Why you could not file the revision in time?
My lord, I have specifically and in detail mentioned in my additional affidavit from paragraph number 5 to my lord 7, my lord. Because my lord, what happened in this case, my lord, the petitioner is not only
Paragraph number?
my lord, 5 to 7, my lord. In my additional affidavit.
Where is the medical document?
Madam, no. I have not annexed madam because so far the fathers.
You have not enclosed.
This is the madam genuine ground that
Hmm?
my client has installed.
Hmm?
Delhi is never madam, so.
Mr. Sorma,
Madam,
what to do?
madam, here, 154 देखो,
197.
197 days with him, madam. Let them speak, madam, this thing, madam.
Those two issues.
Service. It's here for next.
Only 1 year madam imprisonment so far that person he is under madam custody madam. Arrest has been made madam.
Is it believable that you are not in a position to handle the mobile phone?
My lord.
Hmm?
My lord.
Is it believable?
My lord. So far that part is concerned, my lord, what happened, madam? His dependency and ignorance is the basic reason for causing dilemma. Basically, it is such.
Whether ignorance of law is excuse?
My lord, so far that person for the ends of justice, it can be, my lord. For the ends of justice. For
Ends of justice has to be balanced with the ends of justice for the other side also.
So for that part has been concerned, notice was issued, my lord, they have received the same, my lord.
Yes, sir.
Did not appear, my lord.
Sorma, learned counsel for the applicant submits that the judgment in revision, the judgment in appeal, criminal appeal number 21 of 2024 was passed on 22/8/2025, and the petition applicant herein could not contract his counsel in time, and his parent were also suffering from diseases, and he has the burden to look after them. And also due to ignorance, the applicant could not approach this court in time, and that the delay is not, no, and the delay is explained in paragraph number
5 to 7 of
5 to 7 in the additional affidavit. And under such circumstances, he has no, and that the delay is not intentional, rather it is circumstantial, and therefore he has contended to condone the same. Mr. Sharma, any objection?
My objection is that, madam, there is a delay, it is admitted, madam, and when, madam, it is sufficient, madam, grounds which are shown in the, madam, and delay petition, that are sufficient or not, madam.
According to you, it is sufficient or not?
Lordship pointed out, madam, ignorance is the, madam, whether ignorance, madam.
Mr. B. Sharma learned additional PP, however, opposed the application on the ground that the ground assigned is not sufficient for condemnation of delay of 197 days in preparing the connected criminal revision petition. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the application and the documents placed on record, and also perused the additional affidavit filed by the applicant. In view of the explanation so put forwarded in paragraph number 5, 6, and 7 of the additional affidavit, and also considering the submission of Mr. Sharma learned counsel for the applicant, this court is of the view that the delay is sufficiently explained, and accordingly the same stands condoned. In view of the, in terms of above this IA stands dispose of. In view of the order passed in the IA, now the registry will register the revision petition and place the same before the court. as soon as practicable.
Alia.
Item number 27 and 28.
May I please your lordship, may I pray that 28 may be taken first, revision.
Okay, before my land, start arguing. The same issue has been, same order has been upheld by our coordinated bench of this board. Same order, it has been challenged by my landed friend.
In fact, but there are three accused, my lord. For one accused, I came to know that the honorable coordinate bench has upheld the extension of time given by the land special judge Kachar Silchar, which is under challenge before lordship. My lord, in a similar case, my lord, I'm submitting one order, my lord, where our own High Court as well as the Supreme Court judgment has been discussed, submitted by me. It was my case, my lord, I argued the matter, and Honorable High Court has set aside the extension of time as legal provisions and requirement of law was not fulfilled. That's why, my lord, in this case also, though, my lord, I cannot go beyond the findings of the landed honorable single judge, but I have nothing to say against that. But question is that, my lord, whether extension was duly done, legally done, or as per law. In this instant case, my lord, it was not legally done because without any progress report submitted by the PP, only IO has submitted application that I cannot complete the investigation. Another 90 days is required after 180 days. And PP also submitted that thing without that. And no copy was served to the accused person. That is a mandate of our own High Court, my lord, in a case of Gyanananda Prasad versus the state of Assam, Honorable Justice B.D. Agarwala.
So the order you have challenged here is upheld by the coordinate bench.
Yes, yes, is upheld by the coordinate bench for another case, my lord, which I came to from a learned friend just now. Now that is the hurdle now before your lordship, my lord, because one court is upheld, my lord.
Mm.
And my lord, 462 days without trial, my lord, till today.
So what to do?
I leave it to lordship.
Better you withdraw this petition.
My lord, I leave it to lordship. I will not withdraw it, my lord. Your lordship pass whatever order, this giving the reference of that order.
Heard Mr. Biswas, learned counsel for the petitioner, Mr. Kyle, learned standing counsel for the respondent. In this petition under section 428 of the BNSS 2023, the petitioner has challenged the order dated 27/10/2025 passed by the learned Special Judge Kasar Silsor in departmental case number 01/CL/METS/METS/HQRS.PREV/SH/2025 -26 dated 1/5/2026 corresponding to NDPS case number 12 of 2026. It is to be noted here that by impugn order dated so and so, the learned trial court was pleased to extend the period of completion of investigation. Period for completion of investigation for further period of 3 months, which will make it 90 days in terms of section 36 capital A, which will make it 4 of the NDPS Act 1985. Mr. Kyle, learned counsel for the respondent, producing an order dated 28th of March 2026, passed in criminal petition number 1626 of 2025, submits that same impugned order dated 27/10/2025 in this petition was challenged in the aforementioned criminal petition number 1626 of 2025, and a coordinate bench of this court by order dated 28/3/2026 has affirmed the impugned order. And as such, this present petition, in view of the order dated 28/3/2026, passed in criminal petition number 1625 of 2025, become infructuous, and accordingly, he has contended to dismiss the same. Having heard the submission of learned counsel of both the parties, this court has carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 27/10/2025, and also the order dated 28/3/2026, was by a coordinate bench of this court in criminal petition number 1625 of 2025.
No, no.
It appears that the coordinate bench of this court has affirmed the order dated 27/10/2025 in NDPS case number 01 struck. Continue, court. In that way of the matter, the present petition is squarely covered by the order dated 28/3/2026, and as such, this court is of the view that this petition is devoid of merit, and accordingly the same is dismissed. The order produced before the court today by Mr. Kyle shall be part of the record. In BA,
Well, B I will submit my letter now. Now B remains, I will submit. In this case, my lord, 462 days behind the bar, my lord, 36 and 48 has not been complied. 36. Though my argument is going on today,
how many days?
462 days.
462 days.
Without, still today, no evidence was, nothing was, no charge was also framed. My lord, scan copy has come, my lord, kindly peruse the 48 and 36.
48
and 36 of the BNSS.
48 and
36.
Where is the forwarding report?
My lord, kindly peruse the arrest memo. I am giving page 22, my lord. Arrest memo.
22.
22. 36 requirement, my lord. 36(3). Arrested by at least one witness who is a member of the family of a person arrested or a respectful person of the locality. That is 36(b). That is the mandate, my lord. Your lordship will find only the accused harm impression has been taken. There is no members of family of attachment or the respectful person of the locality. 48.
36B.
Yes, 36(b). Today, my lord, on this point, at length there was because all 36 was referred to the larger bench, where I am also one of the cases there today.
Friday is the fixed for final hearing.
Friday is the fixed final hearing.
Where?
Friday.
Before division.
Before division 36, because there are so many judgments. Half of the honorable judges are in favor of 36. In some 36 cases has not been complied by other coordinate benches. That's why my Lord Justice Das has forwarded this matter to the Honorable Chief Justice, madam.
When the matter is fixed?
Next Friday, madam. Friday.
Friday of this week or
This
the
week,
next
yes,
week?
actually this week.
So
7th of August.
we'll list the matter on
7th, but 8th, my lord. Or 10th, my lord.
on 10th. But are you sure that on that day
Yes, I
the
was there.
matter will
My
be
case is there. I was
finally?
there. I was there in this case.
Okay.
There are so many lawyers in this case whose
Heard
cases are.
Mr. Heard Mr. Biswas, learned counsel for the petitioner, and Mr. Kyle for the respondent. Mr. Biswas submits that in respect of non-compliance of section 36
Yes.
B of the BNSS 2023, no, the requirement of compliance of in respect of the requirement of compliance of section 36 BNSS 36B BNSS is pending before a division bench of this court, and the matter is fixed on Friday. And as such, Mr. Biswas submits that this matter may be listed on Monday. We are allowed to list the matter on Monday.
Obliged, my lord.
May I please, your lordship? Lordship. So proceeding, your lordship, notice served to the respondent number 2, your lordship.
When no one appears,
Not appears, amicus curiae have to be appointed. Your
or Ms. Bora, learned counsel for the applicant, and Mr. uh, learned counsel for the accused, and Mr. B. Sharma, learned additional PP for the state respondent. Mr. Bora, Mr. Bora, Mr. Sharma, learned additional PP submits that service upon respondent number 2 is completed, but no one entered appearance. And accordingly, Ms. or please come.
List come, list.
Am I custom? Become name. Sanjana Newar, I think. So Sanjana Newar, are say regular? Sanjana Newar.
Newar. S. Newar.
Yes, Newar
Regular no,
is appointed as amicus to represent the respondent number 2. Rest shall reflect the name of respondent number, reflect the name of Sanjana Newar in the cause list, and also shall furnish the application, copy of the application and relevant papers to her well in advance, and list the matter on short date
shorted.
12/8.
Can it be Tuesday, your lordship, and next Tuesday, your lordship? May I please, your lordship? Lordship, as per the office, no service is not complete, my lordship.
Service not completed.
Service that I am not aware with regard to.
Okay.
So
Okay.
an amicus may be appointed.
Miss Third, Miss S.G. Barua, learned counsel for the accused, and Mr. B. Sharma, learned additional PP for the state respondent. Mr. Sharma apprised this court that service upon respondent number 2 is completed, but the respondent number 2 remain unrepresented today, and accordingly, P. Sharma, Partusa Sharma is he regular? Partusa. Partusa Sharma. Srimati Partusa Sharma is appointed as amicus to represent the respondent number 2. Rest shall reflect the name of respondent number, reflect the name of Partusa Sharma in the cause list and also furnish the application, copy of application and relevant papers to her well in advance and list the matter on. Sorted.
My lordship, but sir, can it be fixed on 25th because I will obtain in between the certified copies of the evidence.
25th.
25th,
All right.
because they have in between two evidences. Oblige, my lordship.
Service report.
Not distributed.
What to do? You want to approach the trial court or we will dispose of this same? We have to call for the record then.
TCA may be called for.
TCA. Okay. Heard Mr.
Jay Hatimuria.
J. Hatimuria, learned counsel for the petitioner, and Mr. B. Sharma, learned additional PP for the state respondent. Mr. Sharma submits that service upon respondent number 2 is yet to be completed. Then he also apprised this court that after completion of investigation, the IO late charge sheet being charge sheet number
65 of 2026, 31/7.
before the learned trial court. And in that view of the matter, it is provided that rest shall call for the scanned copy of the TCR from the learned trial court. Mr. Sharma shall also obtain the service report upon respondent number 2 and rest shall list the matter on sorted 13.
In this case, Lordship, sources has been submitted, Lordship, and registered special case number 67, 2026, Lordship.
Case they received?
No, my lord. Here, CC not received, my lord.
Service report is also awaited.
As per their information, my lord, that charge sheet submitted, my lord.
Charge sheet submitted.
My lord. What should be the?
You have received a copy. Charge sheet?
No, Lordship, special case number 67 was registered, Lordship.
Special PS case number 60.
Session special case number 67, Lordship.
Session special 67.
TCR may be called for, Lordship.
Heard, Mr.
B. Datta.
Learned counsel for the accused and Mr. B. Sharma, learned additional PP for the state respondent. Office note dated 24/7/2026 indicates that service report upon respondent number 2 is still awaited. Accordingly, it is provided that Mr. Sharma shall obtain service report from the officer in charge jurisdictional PS and place the same before the court on 14. Learned counsel for the petitioner submits that in the meantime, IO has completed investigation and submitted charge sheet before the learned trial court upon which session special case number 67 of 2026 has been registered, and he submits that the scanned copy of the record may be called for from the learned trial court. Accordingly, it is provided that rest shall call for the TCR from the learned trial court, fixing the matter on 14.
My lord, can it be after sunrise, my lord? My senior is coming, sundown women.
F2, my lord.
PP is suggesting at 2 miles.
I don't know if he has come, I will.
Fine.
24.
Perhaps charge sheet has been submitted in the case. Madam. Can copy of the PCR may be called. No, NDPS intermediate quantity.
Is it POXO matter?
No, my lord, in the NDPS, my lord, intermediate quantity.
NDPS. When you, you
I
have
was
been
arrested on, my lord, 14/6/26. Today is 53 days. Madam.
What is the quantum
three-
of the contraband
My lord,
substance?
3 kg of ganja, my lord.
Pardon?
3 kg of ganja, my lord.
Mr. Sharma, he is behind the bar for 53
3 days, my lord.
days. And 3 kg of ganja.
3 kg, my lord, 18 gram.
53 days.
53 days, my lord.
3 kg, 3 point.
3.018, my lord.
Let him go. Let's try hard, Mr. Nawaz, learned counsel for the accused. And Mr. B. Sharma, learned additional people. No, without going through the DCR, we can consider his petition is for behind the bar for 53 days. And the quantity of contraband substance is 3.018 kg. Very little. Is it intermediate quantity
Intermediate.
or
Intermediate, man.
also heard Mr. B. Sharma learned additional PP for the state respondent. This application under section 483 of the BNSS 23 is preferred by accused Hairul Islam, who has been languishing in jail as in connection with Nalbari PS case number 109 of 2026 under section 20 within bracket B, within bracket Roman 2, within bracket capital B, stroke 25, stroke 29 NDPS Act. It is to be since 15/6/2026. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Sanjeev Das, SI of Police, Nalbari PS on 14/6/2026. The allegation against the present accused is that 3.018 kg of ganja was found in his possession on 14/6/2026 at around 1:10 AM. While he was driving a vehicle bearing registration number ES02U-4247 at Joymangla within the jurisdiction of Nalbari PS. Learned counsel for the accused submits that the accused was arrested on 15/6/2026 and for last 53 days he has been languishing in jail hazard. He also submits that the IO has completed investigation and submitted search sheet, being search sheet number
128 of dated 31/7/26.
He also submits that the quantity of contraband substance allegedly recovered from the possession of the accused is 3.018 kg, and that since search sheet has been submitted, the accused will appear before the learned trial court and will face the trial, and under such circumstances he is contented to allow the accused to go on bail. Per contra, Mr. Sharma learned additional PP has opposed the petition and he submits that since charge sheet has been submitted, the TCR may be called for from the learned trial court. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record. When it appears that the accused was arrested on 15/6/2026, and since then he is languishing in jail as of for last 53 days. The investigation of the case has already been completed and submitted charge sheet against the present accused. And further, it appears that 3.018 kg of ganja was recovered from the possession of the accused, and the same is of intermediate quantity. Since the investigation has already been completed, then charge sheet has been submitted, the question of hampering investigation and the tampering witnesses does not arise. Now the trial will start and the accused has to prepare his defense. Keeping the aforesaid facts in mind, this court is of the view that further custodial detention of the accused may not be warranted in the interest of investigation, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 25,000 with one security of like amount to the satisfaction of the learned
Special judge,
special judge,
Nolbari.
special judge and DPS Nolbari, the accused be enlarged on bail. Next.
I'm deeply obliged, my lord. Maybe fixed for at 2 p.m. my lord. T.J. Mohanty will argue the case, my lord.
Pardon?
T.J. Mohanty will argue the case, my lord.
Who?
T.J. Mohanty, my lord.
At 2:37.
37.
But earlier opinion, TCR was called for, not this.
Is here not received? Heard, Mr.
Jet Rahman.
Learned counsel for the accused and Mr. Borthakur, learned additional PP for the state respondent. Mr. B. Sharma. Mr. B. Sharma apprised this court that the TCR was called for, but the same has not yet been received. Accordingly, it is provided that recessal issue urgent reminder to the learned trial court for transmitting the scanned copy of the record along with the case diary and to list the matter on
17 August.
17 of August.
38.
May I please your lordship? My lord, 43 days behind the bar. I am a professional driver. My vehicle was hired by some person, my lord.
How
And
many
out
days?
of those person, one person has already
Oh,
been
how many
granted bail
days?
by the special session court. 43 days, my lord. 43 days behind the bar.
43 days.
FIR is at my lord, page 11. The allegation is that some persons have opened fire in front of the house and tried to trespass to their house.
What are the sections?
Section
25, 1A, 27. Huh? Yes.
my lord,
What
land
is the
session judge-
punishment for section 25, 1, capital A,
Yes,
Arms Act?
yes, it is there. Extended up to 3 years and extended up to 7 years, my lord.
No.
Let the case diary come.
That I am submitting 25 1A Arms Act, yes.
So why the case
Not
diary is
less
not
than 3 years.
Requisition.
It is down.
on
My
next
lord,
Tuesday?
my lord, already co-accused has been granted bail by the special session judge, Kamrup, indicating the after CD, revealing that taking into consideration of the nature of the allegations made in the materials on record, including the statement of the seizure list and the witness indicating the part played by the accused the said allegation. This court is of the considering opinion that further custodial accused Somarali is not required. Somarali is the person who hired my vehicle. I was a driver. I did not. My vehicle was parking outside.
We'll peruse the case diary. We'll see the role played by you.
I was a driver, my lord.
Maybe.
I have not played any role, my lord.
Heard Mr. Biswas, learned counsel for the accused, and Mr. Watney B. Sharma, learned additional PP for the state respondent. Mr. Sharma submits that the case diary has not yet been received. Accordingly, it is provided that recessal lays the matter on short date.
17, my lord, are too long, my lord, here.
Short date, okay.
It will come from, my lord, 13.
On that day, Mr. B. Sharma, learned additional PP shall produce the case diary before this court. None appears for the accused on call, leaves the matter after a week. In the event of subsequent non-representation of the accused, appropriate order shall follow. However, Mr. B. Sharma is present.
CD also not.
And CD has also not yet been received.
Well, matter fixed on 17.
17. Same order. None appears for the petitioner on call. For the accused on call.
41.
May it please your lordship, the matter has been pending for several days. On each occasion, the learned it shall be public prosecutor sought time on the ground
Did
that
he
the
receive
case diary
or
was not been received. 41. Even on the last date also, on the same ground. I respectfully pray that the honorable court may either decide the application on the available material, get an interim protection.
But the commercial quantity of
Yes, my lord, but
contraband
no recovery from the
substances involved
petitioner.
here.
Or petitioner was not present in the vehicle. Only on basis of the co-accused who have disclosed the petitioner's name. So if no criminal antecedents was there,
It would not be proper to dispose of this petition without perusing the case diary. Why case diary is not available?
Instruction from our office also, my lord, that requisition was sent by the party that. We'll take instruction, my lord.
Who is the IO? And from which place the CD will come?
My lord, it's still servant. My lord, yet to I'll take instruction whether 30, we have to submit, my lord. I'll take instruction. Whether 30 submit.
Okay, at 2 p.m.
my lord.
In this case, lordship, basically, the FIR is paid 35, lordship.
Here also CD not testing, my lord.
Mr. Dutta, this case is under scheduled castes and scheduled tribes also.
That may not be, lordship, there, lordship, it is
But
registered.
the question is whether anticipatory bail application is maintainable. There is a
It is
decision in
there,
the Supreme
lordship.
Court.
The power is there. If the allegations, lordship, does not support that, then lordship can enter it. And the judgment is there, as sanctioning. At this moment, lordship, we have not paid. It is, but the law has
Did he
been,
received or not?
Not testing, my lord.
lordship, from 1/5/2026, lordship, this is fourth time.
From where the CD will come?
It is from Dibrugarh.
Dibrugarh. Why CD is not available then?
But it is. The requisition also sent of 23/7, my lord, 26. My lord, I'll take instruction, my lord, may start it also make submit, my lord. Instruction, my lord.
Okay, at 2 p.m.
My
then.
lord.
Add to.
May it please your lordship. For this PRS bill application, I am a victim of the husband-wife issues of my son and my daughter-in-law. My son had filed an application before the family court, praying for restitution of conjugal rights. This led to a conflict between them, and my daughter-in-law lodged the Ejahat, as well as my son also lodged a complaint case. Now, my son is out on bail, and I am an assistant is out on bail. My wife is not being attacked because she has gone and given a statement. No, I'm an assistant teacher. Member. All these matrimonial issues between my son and my daughter-in-law. I'm not supporting or condemning anyone, but this is not the way the things have to have been done. May I read, Miller? This order, Miller.
No, not necessary, but you produce the case diary.
No, I'm praying
Let
for
him,
interim protection.
let him go Prior's bill, interim
Lordship.
Prior's bill.
My lordships.
Heard, Mr. Bunny, learned counsel for the. CD is not available today. Today we'll consider the interim peer. Yes. No, we will independently examine the case diary. We will not go by the order of the session judge. No. He is a teacher.
Assistant teacher, Miller. Now the executions are always to go to school. That's the difficulty.
Let the city come. If there is material, then we will not continue with the interim peer.
No, my son has been granted bail, so I'm presenting this to your lordship.
No, maybe today the city is not before the court. Therefore, we consider it.
Grateful, Miller.
Third, Mr. Bonik, learned senior counsel assisted by Mr.
M. Ahmed.
Learned counsel for the accused. No, learned counsel for the applicant, Mr. B. Sharma, learned counsel, learned additional PP for the state respondent, and Mr. S. A. Sharma, learned counsel, the respondent. Number 2. No, you are not respondent here.
He's got an
The informant, Miller. He's the informant. It's okay.
You have filed any Ukalatnama here?
Yes.
When? Okay. Learned counsel for the informant. Mr. B. Sharma, learned additional PP submits that the CD is not available before this, or he has not received the case diary, and he pressed for a short date for producing the case diary. Fair allowed. Mr. Bonig, learned counsel for the applicant submits that the applicant is a teacher, assistant teacher of
Page 16, Miller. That's Sagalchara Part 2 LP School. In Dhupri.
and that
Gauripur, bro. Page 16.
assistant teacher of Sagal Sara Part 2 LP school. And that he could not attend the school on account of the pendency of the case. No, on account of the apprehension for being arrested, for being arrested. No, for being arrested in connection with Dhoburi PS case number 230 of 2026. And that till receipt of case diary, the interim pair of the petitioner may be considered. The learned counsel for the informant, however, opposed the pair on the ground that the learned session judge has dismissed the pair of the petitioner on the ground of availability of sufficient incriminating materials. However, taking note of the fact that the applicant is a teacher and he has to attend the school, And also considering the fact that the learned additional PT has failed to produce the case diary before this court today, this court is inclined to extend the privilege of interim POS bail to the applicant till production of the case diary before this court. On when
I don't know, interim is it interim?
21st of August. Till then, in the event of arrest of the applicant in connection with Dhubri PS case number so and so, he shall be enlarged on interim PRS bail on his executing a bond of rupees 20,000 with one security of like amount to the satisfaction of arresting authority.
That copy may be kept as a part of a record, that he is unable to put it back in there today. I problem, that is, I.
Therefore, said privilege is however subject to the following three conditions. The report, the WT message produced by Mr. Sharma for failing to produce the case before this court shall be marked as annexary and be tagged with the record.
Grateful Lordship.
Arresting authority.
No, please go. Matter may be taken at 2 minutes.
Why?
The senior counsel MSEC is leg on
Who-
court number
who?
3 minute. MSEC.
Who will appear?
MSEC.
46.
Wait, please, Your Lordship, this is a pre-arrest bail application, Your Lordship. I am not on interim, Your Lordship. TD was called for, perhaps it is not available. Available. Your Lordship. Only one
Mr.
fact, Your Lordship. Lordship will come to page 19, Your Lordship. There is a medical certificate, medical report, Your Lordship, which says the wife of the petitioner, the date of expected delivery for the birth of the child is on 7/8/26, Your Lordship. Petitioner is a 27-year-old person, Your Lordship. Incident pertains to theft.
No, you are not behind the bar.
No, Your Lordship. However, my child is supposed to be born soon, Your Lordship. As per the report, it is on 7/8, Your Lordship. At page 19 is the medical report, Your Lordship. Lordship will find in the middle portion EDD. Expected date of delivery, that is in the middle portion, Your Lordship. I may be protected till then, Your Lordship, at least, till the CD is called for. Incident pertains to cow
Yes,
theft.
Mr. Sharma.
Here today we have not received the case diary, but I prefer shorted manner, it will come manner, and he, although basically his wife manner, but he is in.
Is a 27-year-old person, Your Lordship. And Lordship, the entire story is that there was a theft of, allegedly there was a theft of cattle, Your Lordship. However, there is a cow purchase or cow sale certificate has also been annexed by the petitioner, Your Lordship, here. The vehicle was also burned.
Let the city come. Heard Mr. K.J. Soikia, learned counsel for the applicant. And Mr. T. Sharma, learned additional PP for the state respondent. Mr. Sharma submits that though by order dated 28/7/2026, CD was called for, the same has not yet been received, and he pressed for a short date for production of the case date. They are allowed. Place the matter on
13 minutes, 1-3.
1-3. Learned counsel for the applicant, however, submits that the wife of the
petitioner,
applicant is in family way, and her expected date of delivery is 7/8/2026, and as such, the presence of the applicant with his wife is very much necessary, and therefore he has contented to extend the privilege of interim PRS bail to the applicant till the production of the case diary before this court. Where taking note of the submission of learned counsel for the applicant and also considering the medical document which is annexed with the application as Annexure C. This court is inclined to extend the privilege of interim period bail to the applicant till production of the case diary. It is provided that in the event of arrest of the applicant in connection with what is the PS case number?
Lordship, it is Dumduma PS case number 227 of 25.
Dumduma PS case number 227 of 2025 under section 305A, 3172, 3174, 336(2) of BNSS 2023, read with section 11. Prevention of Cruelty to Animal Act 13A, 13(1) of the Assam Cattle Preservation Act 2021. On furnishing a bond of rupees 20,000 with one security of like amount to the satisfaction of the arresting authority. Type of privilege is however subject to the following three conditions.
Then method is section 20, my lord. 24. My lord. Okay.
Deeply obliged.
Section 54.
Right, 54. May I please your lordship? Lordship, the CD was called for my lordship. Annexure 1, page 12 of the FIR, my lordship. My lordship, as
Page number?
Annexure 1, page 12 is the FIR. It starts from page number 13, my lordship.
Yes.
My lordship, the petitioners before your lordship are three petitioners, the father and the two sons, my lordship. Petitioner number 1, my lordship, is an assistant teacher, 2 is a doctor, Ayurvedic doctor, and 3rd is a pharmacist. My lordship, here what happened was that while collecting toll revenue in a village, there are some heated conversation took place between two groups, my lordship. As per the FIR, 27 persons' names are reflected in the FIR specifically, and along with it 30-40 unknown persons, my lordship. The petitioners before your lordship, they are not named in the FIR. My lordship, as per the FIR, the allegation is that by the informant that the persons were attacked and for which they are on medical treatment, my lordship. So, my lordship, my submission here in this regard that my submission is that, my lordship, I'm not involved in this matter, my lordship. And my lordship, I'm not aware with regard to the injury or with
Your
regard
name is not there in the FIR.
No, my lordship, my names are not there in the FIR. None of the three petitioners' names are in the FIR, my lordship. There are specifically 27 persons' name in the FIR, and along with it, it is stated 30-40 unknown persons, my lordship. My lordship, yes. Petitioner number 1 already retired, my lordship, recently, and 2 and 3 are also settled, my lordship. 2 was attending patients, and 3 is a pharmacist, my lordship. We have no past antecedents. And I am not
Maybe
involved.
the allegation in the FIR are serious.
My lordship, yes. But my lordship, we were not into my lordship. They stated that some slogans, religious slogans were made, and thereafter my
They have shouted that the BJP government
My
can
lordship,
do nothing.
that I leave your lordship, because my lordship, the allegations, my lordship, yes, there's some politics. That's why I said initially on last occasion, my submission was also on that regard. Some religions, BJP government and all those.
So whether the names of the applicants are there in the
From the I take from the complainant injured matter, they uttered some of the name of the matter, some of the accused petitioners matter. And the injured report matter.
No, and this petition is filed by three petitioners. Whether the names are there in the statement of the witnesses.
Not matter. From the statement of the complainant injured team, not there.
Not there.
Only 5-6 numbers, 6 numbers are there, my lord.
So then, we can allow the application if the victims and witnesses have not named them in their statement. But is Ajay Barua, learned counsel for the applicants, and also heard Mr. B. Sharma, learned additional pages for the state respondent. Apprehending arrest in connection with North Lakhimpur PS case number 2025, no, 225 stroke 2026 under section 191(2), 191(3), 126(2), 1182, 1351(3), 324(4), 3032, 3 within bracket 5 of the BNS 2023. This application under section 482 BNSS 2023 is preferred by 3 applicants, namely Noor Hussain, Dr. Inamul Haq, and Azahar Hussain for grant of previous pay. It's to be noted here that above noted case has been registered on the basis of an FIR lost by 1 Manoj Gogoi, Dipankar Basu, Pranjal Das, Uttam Das on 17/7/2023. The allegation against the present applicant. The allegation in the FIR is that on 16/7/2026 evening at about 5:30 PM, the informants went to the bazaar to collect the tax, and at that time, the accused name in the FIR along with 30/40 others miscreant in a group and in a planned manner, and being armed with sharp objects like dao, rod, knife, wood, and solid bamboo sticks, shouted slogans like Allahu Akbar, Sanak Taluha, attacked the informants, and also shouted that there will not be Osomiyagiri. And even if the informants are killed, then the BJP government will not be able to do anything. Learned counsel for the applicant submits that applicant number 1 is a teacher.
My lordship, he is a retired teacher.
Is a retired teacher, and applicant number 2 is one Ayurvedic
practicing-
doctor. And applicant number 3
is a pharmacist, my lordship.
is a
My lordship,
pharmacist.
he is a petitioner number 2 is a Ayurvedic doctor. my lordship.
And their names find no mention in the FIR dated so and so, and that the applicant are innocent and no way involved with the offense alleged in the FIR, and they are ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. Mr. B. Sharma, learned additional PP, however, produced the case before this court and submits that the witnesses examined so far by the investigating officer has not named the present applicants with the offense alleged in the FIR. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the application and the documents lesson record, and also produced the case there with the assistance of Mr. Sharma, learned additional PP. In view of the materials collected so far in the case diary, and also in view of the submission advanced by learned counsel for both the parties, this court is of the view that custodial interrogation of the applicants will not be required in the interest of investigation, and accordingly this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with North Lakhimpur PS case number so and so under section so and so, this shall be enlarged on PRS bail. Under executing a bond of rupees 20,000 each with one surety of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. CDV rated.
Obliged, my lordship.
May I please, Your Lordship? Lordship, I have a prayer, Lordship. Lordship, in item number 30 and 40, I could not be reached at time, Lordship. I was at CJM Board. In the meantime, I have reached, Lordship, order has been passed.
Already that has been given.
Lordship, in the 39, 40 and both are same matter.
Pardon?
Lordship, same matter, Lordship.
Lordship, we filed the additional affidavit, Lordship, but there one mistake, yes, Lordship. We are not mentioning the 480/6, Lordship. And the entire thing we mentioned in the affidavit, Lordship, by mistakenly, Lordship.
Okay. Okay. Itanova. Itanova, license. After some time, no one appearing on behalf of the PP. Next.
My lord, we have filed the amended constitution. The opposite party, we have, lordship has already implemented the opposite party number 2 in the case. So notice may go in this.
Heard Mr. Sigdar, learned counsel for the petitioner. And Mr. B. Sharma, learned additional PP for the state respondent. Mr. Sigdar submits that he has already filed amended constitution. Including the informant as respondent number 2. Let notice be issued to the respondent to the office of the PP. Gauhati High Court. And raise the matter on. Mr. Sharma, service report, when you will be able to produce?
17, my lord. 17, my lord, problem, my lord. I will be outside, my lord. 19, my lord.
19. This sarcited case.
My lord.
Sarcited case.
My lord, here, yes, my lord, sarcited case. Lord.
So TCR will be required.
My lord, already, I think, my lord, TCR received, that may be retained, my lord.
Okay. Recessal is the matter on 17 or 19.
19. Leave love.
May I please, Lordship? My lord, the revision has been filed in respect of a final order was in the mandated case, my lord. This is, my lord, notice may go, my lord. Notice may be issued.
ಅದು ಕೊಟ್ಟು ಮೂರು ಫೋನ್ ಇರ್ತವೆ.
Heard Mr. Islam, learned counsel for the petitioner. In this petition under.
Aku putus apa tanah nak cakap?
Under section 442 for 38.
Ang may lugar, koto may lugar.
Is preferred by the Petitioner for setting aside and causing the impugned final order dated 11/6/2026 passed by the learned judicial magistrate first class South Salmora Mankasar in Miss case number 20 of 2025 under section 144 of BNSS 2023. It is to be noted here that by the impugned order dated so and so the learned trial court has directed the petitioner to pay maintenance at the rate of rupees 3,000 per month. Whether you have filed any revision before the session, Judge?
No, my lord,
No.
not final.
Peruse the petition and the documents placed on record and also peruse the impugned order dated 11/6/2026. Issue notice to the respondent, returnable and
All
forward.
respondent.
The be taken by speed post and also by usual process within a week from today. Recessal call for the scanned copy of the record fixing the matter on 19th of August.
High level.
ठीक है
Yes, Mr. Dubey.
Yes, Lordship. Lordship, we filed the additional affidavit, Lordship, but we are not mentioning there is a 480, the clause 6, Lordship. So mistake, Lordship. But entire all the things we mentioned in the affidavit, Lordship, I have one copy also, Lordship.
ठीक है अच्छा से पूछो ना आप
Yes, madam, any problem with you?
This as per the lordship, this TCR record lordship, the last order was lordship on 18/7/26 lordship. The trial is going on lordship, and lordship they now it's a verge of completion, almost verge of completion.
Whether all the witnesses have been examined?
Lordship, they are examining lordship. Every month lordship the witnesses has come to for appearance lordship. So it is a verge of completion.
How many witnesses are remain to be examined?
Lordship, almost 4-5 lordship.
The 5 Lordship. 5 Lordship.
5.
Lordship.
5 are yet to be examined.
Yes, Lordship. We have to examine.
Lordship.
Lordship,
Lordship, next date is fixed on 11/9/26 lordship, next month only. IO and forensic expert lordship, they are yet to examine lordship.
But madam, you see, the accused is behind the bar for 4 years, 4 months, 16 days.
Lordship, because lordship, this is very serious in matter lordship, and the this lordship PWs also lordship 42 lordship, and that's why lordship as per the record lordship, every month lordship this trial is going on. There's no lapses in trial lordship.
Maybe, but can we expect that within 1 or 2 months you will be able to complete the trial?
Lordship, definitely lordship.
Lordship, may I, Lordship?
Yes.
I have filed the bail application on the last occasion, Lordship, that 2023. At that time, Lordship, 15 witnesses had to be examined in the court. After Lordship, 3 years, Lordship, I am filing this bail application before the Honorable Court. Lordship, please see the order, Lordship. In that very order, reject order, Lordship, it was mentioned that as soon as possible, the trial should be complete. And at that moment also, Lordship, the thing is going on. If day to day, the witnesses have to be examined in the court. But Lordship, 3 years, 4 months, 3 years and the 4 months, Lordship, only having I think that was 7 or 8 witnesses were examined in the court. Now 5 witnesses are yet to be examined in the court, Lordship. I am filing this bail application after 3 years and 4 months. I'm filing this one, Lordship. This is the third bail application before the Honorable Court, Lordship.
This is very serious in nature, lordship. It's a cold-blooded murder, lordship. And Lordship, the accused already
Lordship.
they absconding, Lordship. They have been arrested, Lordship, from the other state. So once they is released on bail, it's going to be very difficult to completion of the trial also, Lordship. So Lordship, only matter of 1-2 months only, Lordship.
Okay, I have been the recent judgment process, the Lekatari, and I have annexed one judgment also to your lordship. Based on the lordship length of detention, lordship. It was in the court that lordship, Article 21 is fully explored in that very case. And the main thing is that lordship here clearly it was mentioned that it is not having a thing is that how much the time should be needed in the court to examine the, but this is having the responsibility of the court lordship, not only having the police, responsibility of the court lordship. Also, please come to that judgment lordship. One judgment I have given lordship and one as a Lekatari lordship. The 2026 lordship. Here lordship, one thing should be given that it jail is the exception and the bail is a rule. It is also mentioned in that lordship. And lordship very clearly is in this case, lordship, the judgment I have you, lordship, accused are 9 years behind the bar, lordship. At the time of the argument, lordship, the bail was granted. Only having a single thing that lordship, there is a total violation of the Article 21 of the Constitution, lordship. And this was the writ petition was filed in the Supreme Court, lordship.
Lordship,
After
this
commission of
trial
the
is
offense,
worth of
you have,
completion, Lordship.
Mr. Dubey,
Yes, lordship.
after commission of the offense, you have absconded from Itanagar.
No, lordship. This is only an allegation that lordship. This is only having application. On the last moment, also this point was in the court, lordship. Thing is that lordship, entire the witness was to be examined in the court, lordship. This is only having a statement that
You have been arrested
Yes, in
outside
Calcutta.
Arunachal Pradesh?
No, lordship. I'm arrested in Calcutta, lordship.
Yes.
I'm arrested in Calcutta. Only have a thing that I'm walking there, lordship. But after later on, 1 month, lordship, I just went from that place to my native place, Bihar. After that, Bihar, when police reached in Bihar, lordship, my parents, lordship, they told that he's going to the walking place of the Calcutta. Lordship. My entire family helped them, lordship. Even my father attended before the DGP also there in the Itanagar there, lordship. He stated, we did not hide anything, lordship. He's a walking person, lordship. He walked there only for the walk, lordship. When the police arrested in the Calcutta, he is not trying to flee away, lordship. On the same place, lordship, where the parents sent him, lordship, on the same place he was arrested there, lordship. There's only a thing is that the crime was occurred in the Itanagar, but he was arrested in the Calcutta. Only this is having a substantial things, lordship, match in the case. And on having a statement of the co-accused. And in this case, lordship, if I'm not going to merit, lordship, but in this case, lordship, not a single eyewitness was there, lordship. Not a single eyewitness, lordship. Only having a thing is that statement of the co-accused, we were arrested there, lordship. And if I'm going to the more in this case, lordship, on the occurred date, lordship, one register was found, lordship. But entire the witness, I am examining the witness also in this case, lordship. This is also I think in the record there, lordship. But police directly arrested the 3 person, lordship, without any showing the reason that how they get the clue or anything to arrest that very person, lordship. Because in register, that very person, the deceased, lordship, he was doing a business of the money, lordship. That means he give the money in interest to other person, lordship. Maximum persons are there, lordship. They have taken money, borrowed money from him, lordship. And we are the 3 person, lordship, who help him in his transaction, lordship. But thing is that, lordship, on the occurred date, not a single CCTV camera, nothing, anything recovered, lordship, but on the basis of that very person walked under him, they should have to be arrested. Not a single eyewitness, lordship, not any evidence, lordship. They found the weapon, lordship. They found the weapon of the case, lordship, that used, lordship, in having one drain, lordship. and on the basis of statement of 161, Lordship, there is a co-accused. But when we are coming to the thing that Lordship, nothing should be, there is no any chain of the evidence in this case, Lordship. My
No, no,
submission is,
Mr. Dubey, you see, in bail application, this court is not entitled to appreciate the evidence.
yes, Lordship.
That is the business of trial court. Anyway,
Lordship, my
Well,
only, I am submitted one judgment, Lordship.
yes, I have seen it.
Yes, Lordship. There's a judgment of the Vaibhav Singh, Lordship.
Mm.
I have annexed in the application there, Lordship.
Yes, yes.
They also is very clearly shows that, Lordship, this is not having a thing to against the right of the accused person because trial is pending. And in this case, Lordship, third time I'm coming this before an honorable court, Lordship, and having a huge gap, Lordship. Not after a few months, 1 year, Lordship, after 3 years, but till date, the case is in the same position, that is the examiner of the witness, Lordship. Not a single, Lordship, 5 more. At that time, 17 witness was examined in the court, Lordship, 17. Only now, Lordship, 5 meter, how 1 and 2 months, Lordship, is the possibility to give
If
the thing,
every
Lordship.
month, Lordship, every month witnesses call for Lordship.
But
And Lordship,
Lordship, everyone should be called for, Lordship.
now
What is the
Lordship,
status of the case? Whether they appeared
now,
in the court,
Lordship,
Lordship. IO is transferred. Please speak the two things which is in the record.
Lordship
IO
may
is
go through
transferred
the
from their
Lordship
Lordship.
record, Lordship.
Several locations he was not appearing in the court, Lordship. Only having the delaying of the IO, Lordship, the case is pending. And the other witnesses are also several time notice has been served to them, Lordship. But they were not appearing in the court. This is the duty of the court, Lordship.
Duty of the court to?
Duty of the court to make them bound to appear in the court, Lordship, because I am not. Only have a thing should give several date, Lordship. Only to give a several date. This is
whether you have insisted upon the court to issue bailable warrant of arrest against the witnesses?
Yes, Lordship. At least, Lordship. At least if the court make them bound to appear in the court, why they are ignoring the court order, Lordship?
Whether you have made any such pair before the trial court?
No, Lordship, I am not mentioning.
You have not made.
Lordship, as per the information I have received from the trial court public prosecutor, Lordship, that the examination of the forensic expert is remaining, Lordship, and the IO of the this case, Lordship. And moreover, Lordship, the fingerprint report also against the accused. It's already, Lordship, it has been established. So, Lordship, this is very serious in nature, Lordship. And moreover, Lordship, in every month the trial is going on. It's speedy trial is going on. In a matter of only 1 and 2 months, Lordship, that is not a ground for the bail at this stage, Lordship. It's a burst of completion.
Okay, we will pass the order.
I have only a single
Lordship,
submission,
Lordship, may kindly go to the
If
record,
there is a
Lordship.
problem in
Kindly,
the
Lordship.
prosecution side, Lordship, that I am belongs from the Bihar or anywhere, Lordship, I am ready to perform any witness, Lordship, government service also there, Lordship. Even the court order, Lordship, on every week, I appear in the police station also there, Lordship. Because of 4 years, Lordship. 4 years, I am behind the bar, Lordship. In any condition, I am ready to fulfill the court, Lordship. Highly obliged, Lordship.
Much obliged, Lordship.
May I please, Your Lordship? My lord, it relates to, my lord, online gambling, my lord. Here, my lord, with all respect, my lord, I'll be very specific, my lord. Online gambling, my lord. Several sections of law have been attributed, my lord. Assam Game and Betting Prohibition Act, Online Gaming Act, and thereafter, my lord, with all respect, my lord, one arms was found. That is also a 60-day period offense. License arm, my lord. Several sections have been attributed. FIR is at page 57.
How long you were behind the bar?
I am, my lord, 64 days. 66 days, my lord. Only one section of law that entails a punishment at the end of trial if convicted, my lord, 90 days. That is section, my lord, with all respect, my lord, 111. My lord, may I just first draw your lordship's attention to the FIR? I'll be very cryptic, my lord. With all respect, my lord. Lordship, may I kindly have a look at page 57. I'm sorry, page 19, my lord. It begins at 19, my lord. And thereafter, my lord, goes on and on, my lord. It relates to online gambling, my lord.
But till now, my lord, till the other date, my lord, with all respect, my lord, no amount was seized, nothing of that sort, no bank transaction, nothing was quantified, my lord. Now thereafter, my lord, I'll place the forwarding report before your lordships, my lord. Page 25, my lord.
Yes.
Against, my lord. Oh, I'm sorry, my lord. Against this accused, my lord, with all respect, my lord, page 25, chronologically 2, my lord. Allegations against him at that point of time, after 7 days police custody, my lord, he was taken to police custody for 7 days, my lord. During the raid, the accused person, Alok Jain, so and so, so and so, so and so, so and so, so, my lord, present inside the room during IPL match and were actively engaged in my lord, betting related activities through computer and other electronic devices. During the course of investigation, it has clearly come to light that in the betting related activities, arrested accused person Alok Jain was acting as the mastermind of the gambling operation. The other 3 accused persons, so and so, so and so, so and so, were also actively assisting Alok Jain in conducting the gambling activities. So it relates to gambling, my lord. But till date, my lord, with all respect, my lord, now bank account seized, everything seized, my lord. Cash recovered. As regards this case, no recovery, nothing of that sort has come out during investigation, my lord. Several sections of law have been attributed, and my lord, with all respect, my lord, lordship may kindly have a look at page 22. Several further sections were attributed, my lord, for addition pair was made, that was allowed. Lordship may kindly have a look at page 22. 22, Lordship may kindly have a look, my lord. Lordship may have found, my lord. There, my lord, with all respect and folded hands, my lord. Operation of illegal online gaming platforms. So this paragraph, number 1, my lord, with all respect, my lord. Thereafter, my lord, unauthorized money lending business. This is 1, my lord. My lord, 3rd, my lord, direct involvement in gambling. During custodial interrogation, because 7 days police custody, and from digital evidence collected during investigation, it has further emerged that the accused himself was actively indulging in gambling activity, thereby attracting the offense punishable under section 112 of the Bharatiya Nyaya Samhita, my lord. So this is very important, my lord. 112 is the exact, my lord, with all respect, my section of law that should have been attributed, and that has been attributed, and that is a 60-day period offense, my lord. May I just read it, my lord? With all respect, my lord. 112, my lord, and he is there for 66 days, my lord. 1122 ले दिया है. And these sections were added, my lord, promoting regulation online gaming. These are all 60-day period offenses, my lord. Only one section of law which was attributed prior hand, my lord. In fact, there in the case 111, that entails a punishment at the end of the trial, my lord. 90 days, and that would not be operative in the facts and circumstances or near the spectrum of the spectrum. So far as this case is concerned, my lord, I'll place that, my lord. My lord, with all respect, my lord, 112, that would be, in my understanding as a student of law, that would be the appropriate section of law, my lord. Petty organized crime. Can I read it, my lord?
Not necessarily.
Because it relates to gambling, my lord. Specific. And 111, my lord, that 90-day period offense, all others are 60-day period offense. 111, my lord, that could have been attracted, or that could have been at play had there been, my lord, with all respect, my lord.
Okay.
May I just read it and place it before your lordships, my lord? It would not.
Not necessary. Okay. Yes. CD receipt.
I would like to point out, my lord, in this case, there are topic regarding materials, my lord. Here, my lord, initially on the basis of credible information, police searched the residence of the present petitioner.
No, Mr. Bortakur, you say the only offense in this case is 111,
Yes, my lord, yes.
which is punishable,
Yeah.
which is 90 days
90
offense.
days offense. Yes.
But is there any ingredients of that offense?
Yes, there are, my lord, he is not, he is a habitual offender. Similar, earlier in 2 cases, my lord, charge sheet submitted against him. And my lord, although my lord, today I have got one, my lord, additional affidavit, my lord, here one CID PS case also there, but in that CID PS case,
Final
he-
report.
final report is there, he was not sent up for trial. Then also, my lord, there are in 2 cases in the year, Borolumu PS case number 543, 2016, and Borolumu PS case number 544, 2016, my lord, against him, my lord, similar kind of offences. One is under arms act, my lord, charge sheet
No.
submitted against him. And my lord, during that, in this case, my lord, police has recovered also 1.32 pistol, my lord. Why, my lord, live ammunition and other.
License pistol, but that is a 60-day period offense, my lord.
No license, my lord.
This is the license, my lord.
License of the, my lord, regarding that, my lord, that is, my lord, whether.
60-day period offense, my
I
lord.
will point out, my lord, regarding this aspect also, my lord. That case was earlier registered, my lord, that he, my lord, did not have any license, my lord. And thereafter, my lord, in the year 2011, and thereafter, my lord, because of that, my lord, there was, I do not know whether that license is a renewed up to date license or not, because, my lord, I have not gone through it. And regarding that, my lord, organized in the how in a organized manner. And my lord, regarding that, against that, considering the aspect of, my lord, money laundering, my lord, there is also, ED also has registered.
We have granted bail, my lord.
Granted bail on technical, granted bail on
Please sit
technical.
down.
Sorry, my lord. Sorry, my lord.
Granted bail on technical ground, my lord. This is not that there is no material or whatever. I am not concerned with, my lord, ED case, because ED case, it is a separate chapter. In that case, he got bail, but there are materials of money laundering in the present case, on the basis of which that, my lord, ED case was registered against the present petitioner. And, my lord, this is not the present petitioner, how he is
No,
involved in money
what is
laundering.
the
And
stage of?
he is custodial in the why required, my lord. There are, my lord, not only one, several, my lord, witnesses, independent witnesses.
No,
How
no,
he treated
Mr.
them,
Borthakur.
how he intimidated them, my lord.
He is already behind the bar for 66 days.
66 days.
Whether
Yeah.
his further custodial
Then also, my
interrogation
lord,
will
why,
be
my lord,
required.
why in this case is required, I am pointing out to your lordship, my lord. Your lordship may kindly peruse the same.
No, that
And
that's all right. But what is the stage of
So
investigation?
investigation is still going on, my lord. Some of the, my lord, accused person not yet arrested, and the present accused person, my lord, while using his, my lord, that is, my lord, using his pistol, how he treated and intimidated not only one single independent witness. There are many independent witnesses, not to disclose anything what is going on inside his, my lord, residence in that apartment. Regarding that aspect, my lord, several statements of the witnesses in the case there, my lord. And, my lord, regarding money trail, my lord, what he has done, my lord. Some of the accused persons were some of the domestic help, my lord. He, my lord, the statement of those domestic help is there. He, my lord, opened bank account in their names. All money trail, my lord, through those bank accounts. My lord, those workers, they do not have any ATM card, anything, my lord. The present accused petitioner running their account. And regarding, my lord, what he has done, my lord, regarding my one police has also arrested one, my lord, Bharat Soni. Bharat Soni, he is the, my lord, DM, he is the proprietor of one DM Jewelers. All those money which he received, my lord, through all these online betting activities, my lord, he, my lord, invested, there is a, my lord, in his, my lord, statement, and police has also seized, my lord, that how in the name of present petitioner in that DM Jewelers, my lord, ledger is there, and account is maintained, and all those accounts, my lord, various monies from the, my lord, all those betting activities, my lord, credited in that account. Regarding that WhatsApp, my lord, transactions, financial, documentary evidence, everything is there in the CD, my lord. And why I am objective and custodial in this case, because, my lord, this is not a, simply, my lord, this is not a only a giving betting activities is not a, my lord, it's a serious offense, my lord. There is only because yes, 60 days offense, that cannot be said that, my lord, what section 111 is also there, because regarding that evidence is also there, my lord. And considering it also as an economic offense, my lord, not only he is the main accused, regarding other prohibited persons, I would like to point out one, my lord, bail rejection order of this coordinate bench of the summary court, my lord. The coordinate bench also held that these are, my lord, serious economic offenses. I am just pointing out one paragraph of the while rejecting the bill. Needless to say that aforesaid activities, including gambling, are an organized crime having serious implications and impact on the economy it is also seen that during investigations, it was found that a huge amount of money to the tune of more than rupees 80 lakh has been found in transaction. Regarding that, my lord, evidence is there because through that the President Jewellers, my lord, Bharat Soni's account, how he, my lord, total amount of rupees 80 lakhs, that is everything regarding that aspect, my evidence is there. In his income tax, he showed his return only 9.65 lakhs. But in a short period of time, within 2 months, my lord, all these transactions, my lord, were there in that account maintained in DM Jewellers in the name of the present petitioner, my lord, which is beyond the declared source of income, the accused applicants as well as of the main accused Olufsen, the present petitioner, my lord, which is nothing but an economic offense regarding validation or the that is those are but regarding that co-accused, my lord, but regarding the present accused, my lord, my lord, and regarding those money laundering activities, although my lord, accused person obtained bail, it was only on my lord, some aspect, my lord, he was granted bail, my lord. Although there are my lord materials regarding that aspect, my lord. So this is organized crime section 111 attracted from the definition itself, my lord. Continuous, my lord, he is involved
Okay,
in
okay.
illegal, unlawful activities, and my lord.
What is the city? Yes, what is your reply?
My lord, I'll reply. He's stealing one part of the story, not the other, my lord. My lord, buying gold, he bought gold, my lord, and the jeweler has been granted the privilege of bail, my lord. And we have annexed that order also, my lord. That is, let me be specific, my lord. He's telling one part of the story. There were 2 bail applications regarding co-accused. 3 were granted the privilege of bail, that he is not saying. 3 were rejected. There is a different story, my lord. First of all, my lord, the offense has to be a 90-day period offense. What 111 says, my lord, that is why I am saying, my lord. First of all, my lord, can I just place it, my lord? That DM jeweler, he invested money, my lord. That is why ED arrested him. He got bail because of violation of 4748. That's a different matter. But my lord, the jeweler was granted the privilege of bail. It was by bank payment, my lord. If somebody has money, he buys gold because gold can be bought not by cash, only by bank transaction, my lord. And that bail order of the jeweler, it reflects everything that occurs at page 45 of my application, my lord. He's telling one part of the story, my lord. 45. And there, my lord, it is reflected. Lordship, may kindly have a look, my lord. Para 12.
Page 47.
Page 47. Buying gold is no offense, my lord. ED booked him, my lord. Well, that's a different matter. 47, para 2. Can I just read it, my lord, with all respect, my lord? Alok Jain purchased gold and silver from the peasant petitioner, the jeweler, my lord, 80 lakhs he is saying. And this is clear from the documents available in the record. Alok Jain might have converted his ill-gotten money into gold, but that does not mean that the peasant petitioner has aided Alok Jain in his illegal activity. Money, my lord, income tax will look after. There is no doubt that the present anyway, my jeweler involved in selling gold and silver, everything by bank transaction. Everything has been seized, everything is all right, my lord. And secondly, out of 6 co-accused, my lord, 3 have been granted the privilege of bail. I'll place that authority before my, sorry, not authority. Authority, my lord, that bail order before your lordships. Now, my prayer is this, my lord, all offenses are 60-day period of offenses. I have a license. Even the AMSEC section attributed, that is also a 60-day period offense, my lord. I am there for 66 days. Now, my lord, kindly see to be 111, they cannot override the law. Kindly have a, my lord, with all respect, my lord, can I just read 111, my lord?
Not much.
There, my lord, it is says, my lord, if explanation 2, my lord, past 10 years, my lord, case must have been charge sheeted against him, and thereafter cognizance must have been taken, my lord. In my case, my lord, one case is.
Mr. Mahajan, you say a coordinate bench of this court has already held that it cannot be negated that aforesaid activities fall under organized crime as defined under section 111 of the BNS 2020.
Lordship is correct, my lord. That time, my lord, he had 3 cases. They were telling that all were search-sheeted. Now we have come with documents, my lord. One has ended in final report against him, my lord. And 2, no charge sheet, my lord. That is why we have filed an additional affidavit, my lord. Let them seek a report from the police regarding the, my lord, the status of the cases, because I'm just reading a line, my lord. 111 says, my lord, to fall within the ambit of 111, this has to be, my lord, this has to be there. 111 Roman 2, my lord. Can I just read it, my lord? Continuing unlawful activity. Have I made it, my lord? May I just read? Means an activity prohibited by law, which is a cognizable offense punishable with imprisonment of 3 years or more, undertaken by any person, either singly or jointly, as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheet have been filed. Here, one has ended in final report. Rest 2, no record. But we have annexed it, my lord. I'll read that, my lord. Filed before a competent court within the preceding period of 10 years, and the court has taken cognizance of such offense. And in our affidavit, my lord, with all respect, they mention in the forwarding report that I was earlier involved in, my lord, 3 gambling cases, my lord. Page 26, my lord, of the additional affidavit, my lord. Sorry, my lord, petition. 3 cases they have mentioned, my lord. Present forwarding report, my lord, page 26. 14, my lord. It reveals during investigation that the arrested accused person Alok Jain has earlier been arrested and forwarded to judicial custody in CID page number 1927. That has ended in final report, my lord. That we have stated in the additional affidavit, my lord. And second 2 cases, my lord, Bhorolumuk PS 543 2016 and 544 2016. Regarding status of those cases, my lord, lordship would kindly have a look at additional affidavit, my lord. Let them seek a report, my lord. No case fair. Otherwise, how can they bring in 111? Page 85, my lord. If you are wrong, my lord, let them seek a report. Page 81, lordship, kindly have a look, my lord. Out of 3 cases, 1 had ended in FR against him, my lord. Page 81, my lord. Lordship may have found, my lord. Moreover, IO has found no material against Alok Jain, and so and so. The rest are not necessary. Releasing him from the instant case. CID PS case is gone, my lord. Regarding the rest 2 cases, page 82, my lord, court has allowed it, my lord. And considering all prayer of the IO is allowed. 1 case absolved. Next 2 cases absolved, my lord. This is the status, my lord. From 84 it begins, and I'll read my paragraph, my lord. Page 84, case number down below, FIR number 543. Lordship may have found, my lord, page 84. Towards the left, my lord, down below, FIR number. This is the second case, my lord. And status is status 2. Next page, my lord. Page 85. Record not found. So taking cognizance is impossible, my lord. Page 85, my lord. Lordship may have found, my lord. Page 85, my lord. Record not found. So not to talk of it being charge sheeted, not to talk of the taking cognizance, even, my lord, record not found, my lord. Page 85. The third case, my lord. Page 90. Case number is at 90, my lord. Page 89 towards the left, my lord. FIR number 544. Out of 3 cases, 1 had ended in by sending him not sent up, my lord. He was not sent up for trial. Other 2, my lord. Here also, same case number, my lord. Nobody can dispute it, my lord. Page 90, record not found. If they are, my lord, sanguine that something, my lord, is contrary to whatever is there on record, my lord, the computer has not displayed, Then let them call for a report tomorrow regarding the, my lord, status of these two cases, my lord.
I have all records with me.
No, my lord, how?
With me, my lord, I has handed over to me all those, my lord, charge sheet numbers, when charge sheet file, everything is there.
If charge sheet file, my lord, will not do, may I just read it, my lord? Cognizance has to be taken, my lord.
Everything
Cognizance has to be taken, my lord.
Okay, I will go through the same.
Yes.
Okay,
Have I made my position clear, my lord? Cognizance has to be taken,
okay,
my lord.
we'll see.
My lord.
We'll see.
My lord.
You hand over the
I
case
have
then.
trademarked everything, my lord, everything is here, my lord, the other alia charge sheet also there, my lord. And in two cases, he has my charge sheet submitted, my lord, regarding CID case, he has charge sheet not sent up, but in that case also, my lord, section 1, as per 100, continuous unlawful activity, organized syndicate, and my lord,
What take?
coordinate well judgment regarding economic offense, and my lord, more than one charge sheet, more than two, my lord, here two charge sheet, my lord, number, sections, my lord, everything.
Okay, we'll.
My lord, charge sheet will not do. 1112 Roman 2, my lord. Cognizance has to be taken. One has ended in FR, raised to
Okay,
even
okay.
if charge sheeted, my lord. Without taking cognizance, my lord,
Yes,
they
makes sense.
cannot bring the case within 111, my lord. With all respect, my lord. And that order that 3 have been granted the privilege of bail, that I'll place it before your lordships, my lord.
Wait, please, your lordship. This is also regular bail, my lord. I am in jail for 32 days. The lordship kindly see my FIR page. Vernacular at page 22, my lord. Because there is a translation version, my lord. All various sections are including my lord, arms act also, my lord. But arms act, so far as arms act is concerned, my lord, I have it. This is my license gun, my lord. I annex my license. Page 32 is 22 is the vernacular, my lord.
Yes.
My lord. সন্মানপূৰ্বক নিবেদন এই যে পাথৰকুঁৱাৰী স্থিত অন্বেষা এংক্লেভৰ ৮ নং মহলাত থকা উক্ত পদকীয়া শ্ৰী অভিমন্যু দাসৰ BPO এটা মেনেজাৰ হিচাপে কাম কৰিছিলোঁ 16/8/2022 তাৰিখৰ পৰা 28/6/2026 তাৰিখলৈ মই তেওঁৰ অধীনত কাম কৰি তেওঁ যথেষ্টখিনি লাভ কৰাই দিছিলোঁ তেওঁ মনোবলত কামৰ সম্পৰ্কত মোক দাবী ধমকি দিয়াৰ লগতে ভয় ভাবুকি দি মোক কামত কৰিবলৈ বাধ্য কৰায় তথা মোক আৰু মোৰ সহযোগী কৰ্মচাৰীবিলাকক প্ৰাপ্য মজুৰি দিয়াত ধন আদায় নিদিয়াত মই কামটো এৰি দিয়াৰ বাবে মন কৰিছিলোঁ সেই ব্যৱসায়টো মুঠতে 4,999 4,99,009 টকা বিনিয়োগ কৰিছিলোঁ আৰু সেই মূলধনৰ ওপৰত তেওঁক মই বহুত ধন উপাৰ্জন কৰি দিছিলোঁ যোৱা 28/4/2026 তাৰিখে উক্ত পদকীয়া শ্ৰী অভিমন্যু দাসে তেওঁ বন্দাৰ ঘৰলৈ মোক ফোন কৰি তাত মতাই তাত মোৰ বলেৰো কাৰ ৰেজিষ্ট্ৰেশ্যন নাম্বাৰ চুৱেঞ্চৰ তেওঁ চপাই ডাঙৰ বন্দাৰ ঘৰত মই আবেলি প্ৰায় 5 মান বজাত উপস্থিত হওঁ তেওঁ নিজৰ শনি কথাত মোক বহুৱাই লৈ ব্যৱসায় বিভিন্ন কথা সোধে কথা পাতি থকা পূৰ্বতে তেওঁ বিচনাৰ কাষত তিনিটা ৰাইফল আৰু এটা পিষ্টল চাফা কৰি আছিল কথা পাতি থাকোঁতে মাজতে তেওঁ মোৰ পৰা নগদ 5,50,000 টকা পাব থকা বুলি দাবী কৰি ধমকি দিয়ে তেওঁ হাতত পিষ্টলটো লৈ মোক গুলীয়াই হত্যা কৰাৰ ভাবুকি দিয়ে আৰু পিষ্টলটো মোৰ কপালত লগাই গুলি কৰি হত্যাৰ ভাবুকি দি তেওঁ জোৰ জুলুম কৰি উক্ত খবৰ কাগজত তেওঁ আদেশমতে কিছু কথা লিখি দিয়াত মই পানৰ ভয়ত লিখি দিওঁ আৰু কাগজ দুখন চহী কৰোঁ তাৰ কপি তেওঁ মোক ৰাখিব নিদিলে লগে লগে তেওঁ মোৰ চোলাৰ কালাৰ ধৰি মোক টানি আজৰি ঘৰৰ বাহিৰ কৰি তেওঁ ঘৰৰ কাম কৰি থকা মিস্ত্ৰী কেইজনৰ সন্মুখত চৰিয়াই তেওঁ মোক তাতে 5,50,000 টকা দাবী কৰাৰ ধনখিনি নিদিলে মোক গুলি কৰি হত্যা কৰি তেওঁ ঘৰত পিছফালে গাঁত খান্দি পুতি থোৱা ভাবুকি দিয়ে তাৰ লগে লগে মোৰ ওচৰত থকা তেওঁ পিষ্টলটো বজাই গুলি ফুটাই দিয়ে মই ভয়ত তেওঁ দাবী কৰা ধন মুঠ 3 লাখ টকা অনলাইন যোগে তেওঁক দি দিওঁ তেওঁ দাবী কৰা বাকী 2,50,000 টকা আনিব নোৱাৰাৰ বাবে তেওঁ মুক্ত বলেৰ কাৰখন বলপূৰ্বকভাৱে লান্ধা কৰি ঘৰত ৰাখে টকাখিনি নিদিলে মোৰ গাড়ীখন স্ক্ৰেপ কৰা ভাবুকি দিয়ে সেই গাড়ীখন মোৰ মা ভাৰতী চনলৈ চুৱেঞ্চৰ সিদিনাখন সেই সময়ত ঘৰৰ পৰা পাণ বচাই বতাহাৰ পিছত 2,50,000 টকা দাবী কৰা ধনখিনি অতি সোনকালে আদায় দিয়াৰ বাবে মোক ফোন কৰি ভাবুকি থাকে আনকি মোৰ পাবলগীয়া পত্নী চুৱেঞ্চৰ হ'বলগীয়া পত্নীৰ ফোনত তেওঁ ফোন কৰি তাইকো ধমকি দি মানুহকে হাৰাশাস্তি কৰি আছে গতিকে মহোদয়ে উক্ত পদকীয়া অভিমন্যু দাসৰ বিৰুদ্ধে যথোচিত আইন গোচৰ ৰুজু কৰি গোচৰ কৰিব পৰা প্ৰাৰ্থনা my lord this is the FIR and accordingly my lord case has been registered in various section my lord actually my lord real fact is not that my lord I file a complaint case against him that is my lord I have annexed that my lord That complaint case, my lord, that is page 51. Page 50, my lord. And in complaint case, my lord, everything I have stated. And after knowing that, my lord, this complaint case, that he lost his FIR, my lord. He was a, my lord, businessman. I am also a businessman. I am doing, my lord, a transport courier business, my lord. And I am invested the money in his business, my lord. He has taken more than 9 lakhs of rupees from me. And one fine morning, my lord, he closed up his business and he fled away. Then, why, my lord, he made an agreement with me, my lord, that I will return back the money. And your lordship kindly seen my complaint petition, my lord. I have everything available. But after that, my lord,
What is that agreement?
my lord,
What is that agreement?
every game agreement that not annexed, my lord, but it is in my complaint, my lord. Complaint petition, it is there, my lord.
In which paragraph you have stated about the agreement?
Yes, that is paragraph 10, my lord.
10.
10. Page 53, my lord.
Yes.
Page 53, my lord. Para 10, my lord. Then thereafter, your lordship got in, my lord. Accused number 1, voluntarily executed details handing a self-declaration and resident of the complainant admitting receipt of investment money by the complainant and settlement of the complainant dues, payment of rupees 3 lakhs so undertaken to pay the remaining amount 2,50,000, my lord. And handing over the Maruti Bolero car so in his willfully. My lord, in fact, my lord, the transaction made by me to his account, my lord, I have annexed all these details, my lord. That is my through online, through my lord, through bank, I have made the payment, my lord. Some cash, my lord, some check, my lord, or some, my lord, on online, my lord, on online payment through bank, my lord. So, page, my lord, page 59 onward, my lord, annexure 9, all these, my lord, transaction, my lord. So that is, there is a transaction, he's getting money from me, my lord, that is taking money from me, that is absolutely correct, my lord. So that documentary evidence is there, my lord. Now, my lord, I am not on merit, my lord. Already I am in 32 days in jail, my lord. And their arms, my lord, they are recovery arms from me. But they are licensed gun, my lord. I have annexed the license, my lord, because I am doing courier business in, my lord, Nagaland also. My license is page 41, my lord. So at this stage, my lord, already, my lord, I am 32 days in jail, my lord. And my lord, in fact, if your lordship go by the, my lord, that date of occurrence, my lord, that allows occurrence, that is in my house, my lord, that is on, my lord, date of occurrence is 28, my lord. FIR was lodged on, my lord, 2nd July, my lord, after 4 days, my lord. But my complaint was filed on my 36, my lord. That's 2 days prior to the lodging, 3 days prior to the lodging of FIR.
Yes, Mr. Locker, what is the stage of investigation?
In this case, the stage is the lordship that Nagaland license that has been sent for verification. So that is yet to receive lordship. So till it is required that his custody till then is required first lordship. Second lordship, is one license lordship that is also being seized by in Horkotar PS case lordship, by Horkotar PS lordship because of in another case lordship. It is involved in another case. So that Assam license that has also been seized in Horkotar PS case. This is his own statement. And the Nagaland license which he is using, that has been sent, that is sent for verification from Nagaland. That is not yet reciprocal. And secondly, that 2 persons who independent witness, that is the workers, they have been examined, their statement has been recorded. And as per their statement, they have admitted that on that day this person came to him, they entered into the room, sometimes he went out. But if you go to the Caesar list, you will find that one blank cartridge has been recovered from the courtyard of that accused. So it is also true that when in such a case, that when arms act are involved, nobody comes forward to depose witnesses like those witnesses for giving a statement that he is using that pistol. But that blank cartridge was recovered, seized from the court here, Lordship. It is dear Lordship. So
No, maybe,
Lordship, before getting that report, it may hamper the investigation. So that report will come, Lordship, there, Lordship will decide, because Lordship, his conduct is not good if it repeats from the city, Lordship, because Lordship, his one license is already seized in whole.
no, Mr. Locker, you see, he was arrested, he is behind the bar for 32 days. He was interrogated, then the weapon was recovered and seized.
And not
What
only that,
remains there to be investigated?
but Lordship, that license, that report has to come, Lordship, because Lordship, if that is not, whether it is genuine or not.
No,
that is
that's all
also
right.
required,
If the report is positive, then you are not entitled to file search sheet against him under arms act. If it is a negative, then search sheet will be there. He will face trial.
Involvement is there, Lordship, and apart from that, Lordship, not only that, but that
Involvement is there, all right. You
other two
establish the charges against him in the court by reducing evidence.
other two guns are also recovered from
Other?
other two guns are also recovered from him, Lordship. That is
How many guns are with him?
total, Lordship, probably three guns, Lordship.
Three.
Total.
Three guns.
Three guns, Lordship. Two
Double barrel.
barrel gun, Lordship. He
This is Bible barrel gun, license is not required. Yeah, gun.
this is in season, I have market, Lordship.
Okay, we'll see.
My lord. And so far is my learned friend says that regarding Borpathar PS case, I'm not saying that I'm a good man, but in this involvement in this case, my lord, dear lordship, in Borpathar case, my lord, that was seized, my lord, it was in the Zimmar given to me, my lord. I have that the order, man. Of course, I'm not an expert. Niblum.
Here I have received the information that charge submitted.
That's it.
What do you want? What?
Whether any interim relief was granted to him?
Oh, my lord, NDTS format only.
Where he has gone?
OTT actually.
After some time?
Only 42.
Here we have the received the case there, madam, and investigation is pending, madam. I pay for Monday, Tuesday, madam. For case there, madam. Short accommodation.
Heard Mr. U. Dotto, learned counsel for the applicant, and Mr. Sharma, learned additional PP for the respondent. Mr. Sharma submits that he may be allowed to produce the CD on next Monday. Where allowed? Let's list the matter on
As a
Monday.
last chance, Lordship.
It is
Because-
over. Clarified that no further chance will be granted to Mr. Sharma to produce the case before this court. Tuesday. Okay, Tuesday.
11th.
And it's 45.
May it please, Lordship. My lord, your lordship would be pleased to see FIR at page 9. May I read, madam?
What are the allegations against you?
My lord, allegation is under section 69, my lord. That that offense says that I promise to marry, and by deceitful means I have physical relation.
Also in respect of 112 other similar cases concerning counting of past services. services and said particulars are awaited. And he also submits that he may be allowed some time to obtain instruction in respect of granting provisional pension to the petitioner. Provisional pension to the petitioner, and he press for listing the matter in the next week. We are allowed to list the matter on next Wednesday. Correct. The letter produced before the court today shall be marked as Annexure N and be taken to the record.
Obliged.
May I please, your lordship? Lordship, kindly, matter may be adjourned for the day.
Pardon, miss, your name, please?
P. Kakoti,
Learned counsel. Appearing on behalf of
B. Bhuya.
learned conducting counsel for the petitioner in this matter stands adjourned to be listed after.
Lordship, can it be on Monday?
On Monday may not be possible.
Next week. On 19th of
19th of August.
Oh, please.
2021.
Yes.
It's for payment of rupees 3.5 lakhs. To the response number 2, my lord. I am appearing for response number 2, my lord. Please for the petitioner.
Lordship, the petitioner want 2 weeks time, lordship. Kindly. He's already paid 1.5 lakhs out of 5 lakhs, lordship. And you want 2 weeks times.
1 week time will be granted, my lord. No, and then this should be final, my already taken so much of time, my lord.
2 weeks.
Since when this matter is pending? 2024?
Lordship, we contact with the petitioner suffering from some illness and he's trying to manage the money, lordship. He want 2 weeks time, lordship, kindly.
This should be, my lord, final, my lord. Already they have taken so
Lordship,
much time, my lord.
Art Miss,
As per bin.
learned counsel for the petitioner, Ms. Thakuria for respondent number 2.
Yes, madam.
Who is for respondent number 1? Mr. Borthakur, you were there? Mr. Borthakur for the respondent number 1. The learned counsel for the petitioner pressed for 2 weeks time to make payment of the remaining amount of rupees 3.5 lakhs. 5 lakhs. The learned counsel for the respondent number 2, however, submits that the petitioner herein has already availed several adjournments and a last opportunity may be granted to the petitioner to make payment of the remaining amount. They are allowed, let's list the matter on. Copy, fix it date. 21st August. It is,
My lord,
however,
can it be on 24th, my lord?
all right, 24th. 24th. It is, however, made clear that no further chance will be granted to the petitioner to make payment of the remaining amount.
Much obliged.
23.
You are for respondent. None appears for the petitioner on call. However, Mr. Your name? Learned counsel for the respondent present. List the matter on next Tuesday.
So there is several matter today mentioned of criminal revision 481/25. It is
When?
13 of this next 13.
13.
Yes, sir. This next one.
Learned counsel for the respondent submits that a similar matter is pending
Criminal
on
revision petition number 481/25.
for
481/25.
481 of 2020
25.
25. And the same matter is listed on
13.
13.8. This shall list this matter along with the criminal revision petition number so and so on 13. Later on, Mr. Mukherjee, learned counsel for the petitioner, entered appearance. You are not interested to pursue this petition?
Lordship, I'm sorry, I was in another court, Your Lordship, because
So is it between the same parties
Yes, separate.
on 13? then?
on 25.
This petition has been filed for quashing of FIR. So up to date case that was called for.
Case they receipt?
My lordship, if possible, this matter may be taken last week of this month, my lordship.
Why?
My senior P. Kotoki argued the matter, say he has some personal difficulty, that's why.
Why your senior could not argue the matter today?
He is engaged in another matter, my lordship.
Another matter.
Therefore, I will have to return the case.
And then up to date case diary was
Hmm.
also.
So if the investigation is going on, he cannot keep the CD pending here. Is it the delaying tactics played by you?
Actually, he is the.
Your senior is engaged in another court.
Yes, my
Is not the ground for adjournment. Heard Miss Begum, learned counsel for the petitioner. Then Mr. Portakur, learned additional PQ for the state respondent. Mr. Portakur submits that he has received the case diary. But Miss Begum submits that conducting counsel, Mr.
No.
Who is the conducting counsel?
Mr. P. Kotoki.
P. Kotoki is in legs in another court, and as such, he applied for listing the matter on some other date. They are allowed to list the matter on next week. 20 August. 20 August.
26.
If necessary.
No, you keep it pending. The CDB kept pending.
May I please, Your Lordship?
Yes.
Counsel, Mr. SR Islam is out of station. So this matter may.
Why don't you mention the matter in the morning then? Why?
No,
We made a mention for listing of this matter, Lordship. In this case, Lordship, NIS proceeding, 20% interim maintenance, interim relief was granted by the appellate court, Lordship. So next week, any date, Lordship, Monday, if his counsel is available.
Interim was,
Interim was done, Lordship.
whether that was paid or not paid.
Not paid, Lordship. So next date is before the London trial court on 7th, Lordship. If his senior is available, your Lordship can take it up tomorrow also, Lordship.
after 1 meeting.
Good question.
Okay. As agreed by learned advocates of both the parties, SSL is the matter.
I have objection, Lordship, on Monday, it can be fixed if he is not.
Monday, if it is not available, what to do?
Not available in.
Kiti aayega? Wednesday, Lordship.
Wednesday?
Wednesday.
Okay, Thursday then.
Okay.
Apply.
You see, if you fails to make payment of the interim, then
Yes.
we will cancel the interim order.
They have challenged that order itself, Lordship, by which interim was granted. They have challenged that order, and in this court there is no stay order, Lordship.
No stay order.
No stay.
Okay, okay. So that is the,
It may grant liberty to us to approach the learned trial court for withdrawal of the amount. So that
no,
on
that has
7
not been deposited by them.
No, not deposited, not
Then-
deposited, Lordship. We can file an application before the learned trial court praying to direct them to deposit the amount on 7.
No,
If it is
why
reflected-
liberty is necessary?
Lordship, there is no stay, but Lordship, the trial
Maybe.
court may say that the case is pending before the honorable.
No, 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 no. Since we, no stay was granted, you can go and file an application there.
Lordship.
Obliged.
Here in this case, also regarding Dhimma of the vehicle, water vehicle. Yes, and it was listed losses.
Yes.
Asked me to vote for any effects for decision of the debt. So they get it is specific losses or if it is only the key loss. That there are 29 and 30 loss. That is the guidelines loss. Because this person is the owner and he is being suspected, the case is being suspected now.
So the question is whether court can release the vehicle or not.
No loss, no loss.
No.
That is para 29 lordship. 4 guidelines has been cited here.
So the decision is available with you.
Yes, Your Lordship.
This decision.
Yes, Your Lordship. I may be allowed to submit, Your Lordship. In paragraph number 31 and 32 of the
Hmm.
same decision, Your Lordship,
Hmm.
the four the four guidelines that were, the four illustrations were provided in that judgment, Your Lordship.
Hmm.
So it was held that those are not in a crystallized form. And the law shall be applicable as per the facts and circumstances of this case, Your Lordship.
Hmm.
So my argument and my contention is based on this, Your Lordship.
Hmm.
Your Lordship, my contention is that when the said narcotics were seized from my vehicle, Your Lordship,
Hmm.
under section 37, Your Lordship, the NDPS Act already provides an additional burden on me at the bail stage to prove that I am innocent as a precondition for granting bail. Because, Your Lordship, under section 37 of the NDPS Act, the learned public prosecutor should be mandatorily be given a chance to object my bail petition.
No, no, this is not bail application.
Yes, I understand,
Then-
Your Lordship.
Why you are arguing on 37?
Because, Your Lordship, I am relying on the finding of the bail application. In the bail application, it was recorded that the seized contraband, the quantity of the seized contraband has not
No,
been
no,
recorded.
you tell me whether the proposition laid down in this case, on the basis of the proposition laid down in this case, we can release the vehicle in your favor or not?
Yes, Your Lordship. Because the illustrations that are provided in the said judgment, Your Lordship,
Hmm.
those are not crystallized. In paragraph
Not
31,
crystallized means
those are not to be followed, Your Lordship. As
not to be followed?
no,
The
no.
decision of Supreme
No,
Court is not to be followed by this court?
I beg to retract my statement, Your Lordship. Paragraph number 31 says that in spite of these illustrations, Your Lordship, the facts and circumstances of each case shall be followed. So, Your Lordship, I am arguing or I am providing my submission based on the facts, peculiar facts and circumstances of my case, Your Lordship. This honorable court is empowered to consider the facts and circumstances of my case, Your Lordship. I may be allowed to read paragraph number 31 of the said judgment, Your Lordship.
Hmm.
The paragraph number 31 says, this court clarifies that the aforesaid discussion should not be taken as laying down a rigid formula, as it will be open to the trial courts to take a different view if the facts of the case so warrant, Your Lordship. So, Your Lordship,
So how your case is different then?
because Your Lordship, the contraband that has been seized from my vehicle, Your Lordship, the quantity has not been recorded in the seizure list, Your Lordship.
But the fact remains that some amount of some quantum of contraband substances were recovered from your vehicle.
Yes, Your Lordship.
You are not disputing it.
Yes, Your Lordship. It was recovered, Your Lordship. But my knowledge about the utilization of the vehicle.
That is a subject matter of trial.
Trial, Your Lordship. Yes, Your
Yes.
Lordship. And if in the trial it has been proved, Your Lordship, that my knowledge was there and I have been found guilty, then Your Lordship, this court may initiate the confiscation proceedings as per Section 60, Your Lordship. That is a post-trial proceeding. My application only pertains to the interim custody of the vehicle. And in that regard also, I am relying on the judgment of Sunderbhai Ambala Desai, 2002 Supreme Court, Your Lordship. Because the entire purpose of granting Zimma, that is 451 CRPC.
That was in case of in those cases of which relates to IPC offences.
Yes, Your Lordship.
And it is quite different.
Yes, Your Lordship.
And that has also been discussed here.
It has also been
It has
discussed.
also been discussed here also.
In this case.
Sunderbhai Ambala is also discussed.
Yes, Your Lordship. Your Lordship, Section 60 proceeding, that is a post-trial proceeding, is not a bar on granting interim custody of the vehicle, Your Lordship. So my humble submission before this court is that the vehicle may be allowed to, since it is in a perishable state, it has been lying seized since the month of November. And Your Lordship, this honorable court is empowered to grant the interim custody after executing appropriate bonds, Your Lordship. Restriction may be imposed on me that I do not transfer the vehicle.
Okay, we'll see and pass out. Any other point?
No, Your Lordship.
No.
Obligation.
Item 53.
There are 29 past criteria for cover certificate.
29. Para 29.
29 first criteria also that firstly, where the owner of the vehicle is the person from whom the possession of contraband drugs sustained is recovered. And its consequences, the code of the criminal law that not to be applied in a vacuum but to effects in the consequently it is only in the first two scenarios 1 and 2 that the vehicle may not be released on superiority reverse burden proved by the discharge.
My reliance is on paragraph number 31 of the same judgment, Your Lordship.
Okay. Yes, next slide.
53.
Yes, Your Lordship.
May I please, Your Lordship? Lord, as per the instruction of the petitioner, my lord, I want to withdraw this petition.
You want to withdraw this petition?
Yes, my lord.
Are you engaged counsel here?
Yes. I have taken permission.
Heard Mr. S. Rahman, learned counsel for the petitioner. Ms. Chaudhary for the for the respondent. Amicus. Learned amicus for the respondent number 2 and Mr. Lawcourt for the respondent number 1. Mr. Rahman submits that he has the instruction to withdraw this petition. Accordingly, this criminal petition is considered disposed of on withdrawal. Liberty not required.
Obliged.
Okay, one, my lord, as per my instruction in this case, charge sheet submitted.
None appears for the applicant on call. However, Mr. P. Bordhakar, learned additional PP, present, and he apprises court that after completion of investigation, the IO has laid charge sheet in this matter. Being charge sheet number
26, dated 29/5/26. 421. 421/26, dated 29/5/26.
in view of the charge sheet being submitted in this matter, this court is inclined to close this petition by directing the applicant to appear before the learned trial court and to apply for regular bail, and in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Apply for regular bail. In terms of this evidence, this would